folks, I know there's a history here. I'd like to get this hearing in today. You know, everybody needs to just focus on the relevant facts, okay? I know there's a history here.
Are you talking up by Sunset Mart? Up the hill by the gas station?
Yeah.
Okay. Why did you... All right, who's responsible here?
What's that?
Who's responsible here? Whose house is this?
Yeah, they haven't been drinking or anything, right?
No.
Okay, drive careful, okay?
Will do, thank you.
This is what the other group had that ran away.
Oh, really? You just ditched it? Awesome.
Yeah, those ones kept walking in the car and the other one.
It's truly for the win.
That I was given to. So there was 2 different discs. Okay? They all knew about it.
We're not here to talk about the alcohol stuff, okay?
Okay, yeah.
But this is the second noise complaint we've had here tonight within 2 hours.
How are you?
Good, how are you?
Good. Is this your place?
Yeah.
Perfect. You know why we're here?
I see noise.
Noise, yeah.
Yeah.
Big speaker right there.
Yeah.
Nothing against having a party. Once neighbors start calling in, then we have an issue.
Good morning, everybody. Welcome to the Transparency. First of all, I want to give a special shout out again to all the moderators. It is not easy to moderate a chat of 2,000 people where I believe in uncensorship. So you are always free to comment whatever it truly is that you want to say, as long as you're not attacking another person. So welcome, Truth and Transparency. Thanks you for being here. What did we learn yesterday? That's what we're going to be talking about, as well as some highlights throughout the open portion. And I'm going to tell you how I would have handled some situations. Again, I am not a lawyer, but by God, would I argue with the best of these motherfuckers. Let's go.
Like brains, and like if you need a lot of brains, you're gonna be
We begin with breaking news out of North Idaho.
Just a moment ago, Moscow police confirmed 4 people were found dead in a home.
Xana Kernodle, Ethan Chapin, Madison Mogan, so Haley Gonzalez. They shared everything. They came here together. They eventually get into the same apartment together. And in the end, they died together.
Who is telling the truth? It's been 2 years just about that arrest. 2 years. Who is telling the truth? Come on in. Come on in. In case people don't know this, but actually the first parents to speak to any news outlet was actually the Chapin family. Yes, even before the police. The first parents to get a phone call on 11/13/2022 we at the time believed that it was Ethan's parents or was it Kaylee's parents? Because after the different reporting, with Kaylee's cousin allegedly reaching out to Christy, and then after my talks with Dave, and when people were being notified through Snapchat. So then right now it's a head toss if it was Kaylee's parents or Ethan's parents that would have been notified first. Ethan's parents via his siblings and Kaylee's parents via her niece, Kaylee's niece.
We know that the other, let me get the names exactly right here. We know that Zaina and...
Let me get their names exactly right here. Again, today's goal, if we reach this goal during the broadcast, I will be calling 1-800-FLOWERS, or the place that I want to in Idaho, and we will be delivering flowers to the staff over there at Ann Taylor's law firm, letting them know that we appreciate their efforts for fighting for our rights.
Ethan were at a different party on campus.
On September 12th, there was a vandal alert that was sent out about a potential stabbing threat on Paradise Path. Does this have any connection with what we've seen so far?
Not that we know of it, but we're following everything.
Roommates who lived at that residence. Were the roommates home at the time of the attack?
There was other people home at that time, but we're not just focusing just on them. We're focusing on everybody that may be coming and going from that residence.
So since they were home, was it a hostage situation? And then
No, it was not.
they didn't call it into police. And then were they injured? They didn't call it into police. So were they injured?
No one that we're not going to talk to. There's no one we're not going to interview. There's no one that we're not going to look into. And we're going to do our due diligence. We're going to make sure.
There is no one that we're going to not look into. There was blood, somebody's blood, a male's blood on the banister, on the railing. Who cares? Right? Who cares?
That nothing goes unturned.
I know you said when the call came in, it was for an unconscious person, and also that was a stabbing. It seems, just from an outside perspective looking in, like that would be not the first thing a person calling in would think.
You're right. But the report that we got was that it was an unconscious individual. It wasn't until our officers arrived on scene, went in to do caregiving check on the individual who was unconscious that we found the scene that we found.
Okay, thank you.
Yeah.
Hi, Heather Roberts with ABC News. Just to follow up on what she asked, so the other two roommates were there at the time of the attack?
All the information that we have from our investigation is that, yes, they were.
Okay, but they were unhurt.
That is correct.
So is there any explanation as to why it took so long then for someone to call 911? You have surviving witnesses to an incident at 3 or 4 in the morning, and the 911 call didn't come until noon?
I don't think I ever said that they were witnesses. I said they were there. So, we don't know why that call came in at noon and not in the middle of the night. Would have we loved for that to have happened? Yes, but that's not how it took place. So that's why we're investigating everything still to try to pull all the pieces together.
Were they one of the people, were they the 911 caller?
At this point in time, I'm not going to divulge who our 911 caller is, just because I want to keep the integrity of the investigation at this point, okay?
Okay.
Integrity. We're going to talk all about that word, integrity. They think that revealing the 911 caller would jeopardize the investigation, according to Fry. Wow. Stabbing was originally used, which is confirmed in this dialogue between Fry and the inside reporter, as Fry does not correct her. Instead, he actually says, "You are correct." And then Fry tries to explain that it was a sequence of events, which was a report of an unconscious person that led to the discovery of the scene. So who started the rumor that would be spoke by Christy Gonsalves? My niece called around 1 or 1:30 and said, have you talked to Kaylee? Something bad happened to Kaylee.
And my niece called me and she was freaking out and she said, Christy, have you talked to Kaylee? And I said, yesterday, like last night. And she said, something bad happened.
Somebody came in and shot the place up.
They want to do anything they can to help the investigation, but believe investigators could be missing the mark.
Imagine if you're a parent and you have pertinent information to this, like that dog, and you're asking me to just shut up. It's not going to happen. I'm going to find a microphone and I'm going to talk to it and I'm going to...
Like that dog. Steve just dropping bombs from day one.
Tell people this is important. Whether it helps solve the case or not, how can you eat that? How could you suppress that? It's something you know could help your child and help everyone in that house find justice. But you can't force them to ask you the question.
Christy Gonzalez speaks about what she believes happened in the early morning hours of November 13th.
And went in very methodical. I think he really thought it out. I think he was quick. I think it was quiet, and he got in, and he got out.
Great, again, good morning. And we're going to switch on over now to, we're going to bring in yesterday's. Okay. I got some timestamps marked here that I want to. Ann Taylor was on a roll when she first took over the microphone.
Did not. I apologize.
No preference over here, Your Honor. Well, do you want to argue suppression on IGG and then we can do
This is sped up at 1.5 speed.
Franks? That's fine.
I would need 5 minutes to get my Frank's items ready.
Let's do argument on the suppression of the IGG related matters, and then we can then hear the Frank stuff. That's fine. That's what you're prepared to argue.
Thank you. Your Honor, our position is that the court should suppress the IGG identification and everything that flows from that. This is supported by 4th Amendment of the United States Constitution, due process, Article 1, Section 17 of the Idaho Constitution. Your Honor, there was no warrant for several phases of the search that led to the IGG work, investigative genetic genealogy. And we think every single one of those stages, a warrant was required, none was given, and so this must be suppressed.
Okay, so right there, I've heard people talk about, like, what is she talking about, search warrants? Well, you have to know the IGG interim policy, which I have here. And subsection Roman numeral VII 7. In addition, a search warrant shall be obtained by the investigative agency before a vendor laboratory conducts FGG analysis on any covertly collected reference samples. And then you have to go ask yourself, well, what does reference sample mean? They clarify what a reference sample is, and that's any biological material that you go and collect for the purpose within in this case. And that would most certainly be the trash that you collected. You collected that for samples. And that's in the interim policy. That's just one example that I want to throw out there.
Your Honor, I'd like to identify the 3 stages, and they are when Idaho State Police Forensics Lab, through Moscow Police Department, moved a DNA sample to Othram Laboratories to develop a profile to run through genetic genealogy investigations.
That's also in the DOJ policy. And when people are talking about the chain of custody, that would also be part of that. But the big thing about the DOJ policy is, guess who calls the shots with the DOJ policy for forensic genetic works? That is 100% the prosecutor and the investigating agency, and who had the jurisdiction was Moscow Police Department. So the prosecutor, Bill Thompson, has to agree with the MPD. So whether you want to say Payne or whether you want to say Fry, whoever was, commanding this. But those two collectively make the decision that, okay, we're deciding to go forward and use the FGGS services, which IGG, okay? But there's a laboratory that's contacted. And all of this is documented. All the information that would go back and forth from the lab and the investigative agency, is contacting the lab. So Idaho State Police had it. They don't do SNPs, okay? But they have Ortham is their lab that they work with. They have a contract with. So then ISP sends it to Ortham, and then they started working on it. There would be emails back and forth. And because that's the policy. So investigative agencies shall identify themselves as law enforcement to GG services and enter and search FGG profiles only in those GG services that provide explicit notice to their service users and the public that law enforcement may use their service site. That didn't happen. An investigative agency must seek informed consent from third parties before collecting reference samples that will be used for FGGS, unless it concludes that a case-specific circumstance provide reasonable grounds to believe that this request would compromise the integrity of the investigation. So they wouldn't have to tell Mr. Kohberger, hey, why do you think that they were taking the trash to begin with? What did they have at that point? They had the knife sheath, right? But they also had blood in that house that had DNA unknown, okay? But my argument here would be, you have no idea when you're taking the trash, it's around the holidays, people are in and out of that house. You have no idea whose DNA that you're collecting surreptitiously, okay? So that would meet the burden of taking third parties, collecting them without their consent, which you're allowed to do in this policy. But once you determine that, it has to be that if that is determined that we're going to take this without telling anybody, and it's in the best interest of this case to keep it secret, guess who has to make that approval? If that determination is made, the investigative agency shall consult with and receive approval from the prosecutor. Right here. Bill Thompson, like I've said, from day one is a witness. They must receive approval from the prosecutor before covertly collecting any reference samples that will be used for FGGS, and collecting any samples. And that would be collecting that trash. I don't care what anybody says. What were you planning on doing with it? Using it as a sample. But you don't even know who it belonged to. So those would be third parties, because there could have been like multiple relatives in that house. There could have been people in that house that weren't even relatives that were there, that were friends of the families or whatever. Usually you're collecting something that you know that somebody just discarded it, and it's like you just saw them do it, and then you go and you pick up that because you just witnessed them flick a cigarette butt, whatever. The investigating agency shall also consult with the DLO, which is the director of the lab, okay, who may provide guidance to investigators about the type and nature of the biological samples and may provide most conducive to FGG analysis. Covert collection shall be conducted in a lawful manner. In addition, a search warrant shall be obtained by the investigative agency before a vendor laboratory conducts FGG analysis on any covertly collected reference sample. And do you want to know what they say? You want to know how they're getting around this? And what their argument is that we never sampled it through FG for using IGG. We didn't do it that way. We got Michael Kohberger's or any family members' trash, right? And what did we do? We were running like paternity tests, right? And then we waited. But then I want you to hear this question right here. And this is where my argument would come in when Hitler tries to get Ann Taylor off her mojo of like, this is why this all needs to be suppressed with anything to do with the IGG, is because y'all violated the fuck out of your own policies. And we do have a privacy interest that the government does not just go, oh, do whatever you want. It doesn't matter what these policies are in place for a reason. Otherwise, it's the wild, wild west, right? But this would be my argument to Hitler when he mentions this, to try to get Ann Taylor off of her mojo.
There was no warrant for that search for a SNP profile that could be used to attempt to identify somebody. The next stage would be when that was transferred to the FBI for their forensic investigative genetic genealogy work to try to identify somebody. No warrant was in place for that work either. Finally, there was a trash pull in Pennsylvania, and there was no warrant for that trash pull either. All three of those stages of this case, there should have been a warrant and there wasn't, and this must be suppressed. Your Honor, for the purposes of the Fourth Amendment protections and Article 1, Section 17 of the Idaho Constitution, we are looking to see if somebody has a privacy interest that society is ready to support. In this case, if society is not ready to support suppression of every bit of our DNA when the government does not have a warrant and searches it, there is no privacy right left.
Do you have any cases that hold that?
I do not have any cases that hold that, nor do I have any to the contrary that say that's not the case.
We're dealing with something here that's new. She said it right there. We don't have anything that supports it, but we also don't have anything that doesn't support it. Okay.
Your Honor, this is a situation where this identification was done in complete secret behind closed doors, and it's been continued to be a secret. And that should raise red flags for Your Honor about privacy interests that are at stake. The court can see from the various affidavits in this case that there's a lot of things done that don't say how Mr. Kohberger was identified. And the reason for that is because nobody wanted to talk about what happened here with the genetic genealogy. That search was done by making a profile in Othram Lab. That search did not lead anywhere.
Right there, big boom right there. It started in Othram Lab and it did not lead anywhere. Let me tell you why it did not lead anywhere. Because they did not upload it to sites that they were not allowed to. They did not violate the policy. Understand? That's why it led nowhere. Then, guess who would have to make the decision to then, so the lab then would communicate with Bill and say, this, we have nothing here. We have no centimorgans that like, this is nothing. We can't do anything with this. I mean, we can eventually if more people start submitting into these, sites or whatever, but right now, no. Then Bill made the decision, because that's the only person that can, to then take it from there and send it then to when they want to say, we brought in the FBI. Okay. So hear this part now.
The FBI took over the search, and from there they did things that we have no idea what it is. That entire segment of this case is secret. We have been through several motions to compel to try to get information, and we've gotten very, very little information. The court should know that we learned today about policies and procedures of Othram that we have not.
I was blown away when she said this, because I remember specifically, this is why Roland had to put her in her affidavit. Anne was asking for all the lab procedures, even when stuff is wrong. It's in motion to compel 3 in May of 2023. And it was about all the biological crap and about the lab. And then you have Bill Thompson saying, we don't have, none of that exists. Wait, lab policies don't exist? What the fuck are you talking about?
Been able to take a look at. Those have not been produced. In fact,
they just were produced to her this week.
Told they don't exist. We learned about.
How is that not a discovery violation? How are you turning that over today?
Investigative
discovery deadline for the state was September 9th.
Work that was done after Othram had done the work that they could do and before the FBI took over, that we learned about for the first time this week.
I was blown away. People want to say that Ann Taylor got her ass handed to her. Listen to what she is saying right here, folks. Ann Taylor is saying between the time that Othram had it and said that they couldn't do anything with it to then when the FBI got it, there was stuff that was done in between that time frame that Ann Taylor, investigative work, she says, investigative work that was done between that time frame that we didn't even know until this week. So here it is it again.
To try to get information, and we've gotten very, very little information. The court should know that we learned today about policies and procedures of Othram that we have not been able to take a look at. Those have not been produced. In fact, we've been told they don't exist. We learned about investigative work that was done after Othram had done the work that they could do and before the FBI took over, that we learned about for the first time this week. Not through the motion to compel process. This was a giant secret. When we get to the FBI, we don't know who did the work. You heard that any of that information is redacted. We don't know who did the work. It's a giant secret. We know that by the time the FBI gets involved, the profile, the text file, that's a snip to use to try to identify somebody is more than twice as big when it gets to the FBI from Othram. We don't know how. We don't have any notes. We don't know who did any of the work. We don't have any lab protocols. We don't have any quality assurances. It's not reliable.
You're not asserting that Mr. Kohberger's...
Right here, Hippler. Ann Taylor's on a roll. And then boom, Hippler, straight from my notes that I'm going to read, Hippler comes up with this left field question, in my opinion, because basically how I would have argued this, and I would put a motion in that it was improper. This was ridiculously improper. This question that he is about to ask her would require Ann Taylor to literally divulge client attorney privilege information. Client attorney privilege information. And I'm going to play it, and then I'll tell you why.
DNA sample was uploaded into any of those databases. That his was, like, for example, his own DNA was one that was matched from the crime scene. Not asking whether the crime scene DNA was uploaded, but whether he had, as a, for example, customer of one of these companies, uploaded his DNA.
Well, Your Honor, I don't have the jed.com file.
Okay, did everybody hear that? I'm going to play it back so you guys can hear.
We don't have any quality assurances. It's not reliable.
You're not asserting that Mr. Kohberger's DNA sample was uploaded into any of those databases. That his was, like, for example, his own DNA was one that was matched from the crime scene. Not asking whether the crime scene DNA was uploaded, but whether he had, as a, for example, customer of one of these companies, uploaded his DNA.
Well, Your Honor, I don't have the jed.com file.
She said, you're not asserting. Okay, that would mean like, so she's about to say the most amazing comment, which is, well, I don't have the JED match database. And the reason she says that, and I mean, when I say that this type of a question was so far left field, here's my answer to this. Well, first of all, Your Honor, I believe what you're asking me to divulge right now is client attorney privilege information, because that would have required me asking Mr. Kohberger if he ever uploaded his DNA to one of these third parties. Is that, like, how would I know that answer? How would I know if Bryan Kohberger ever uploaded his DNA to do any of these sites to do Ancestry? I would have to ask him. And what me and him talk about is client attorney privilege information. Okay. So you just asked me a question that you want me to answer. Excuse me? And this is why when people are like, Ann Taylor got stuck or Ann Taylor is this. Ann Taylor was just asked a question that you're asking me to divulge client attorney privilege information. Well, first of all, this has absolutely nothing to do with anything with what you're asking right now. That's number one. And I'm going to tell you why. Because as Ann Taylor's about to say here, she's about to say, well, Your Honor, I don't have the database, the JED match database. Basically asserting, like, I couldn't tell you if I don't have the database, if he ever uploaded it. But she was so just like, wait, what the fuck is he? I can't believe this is happening type of thing. I would have been like, what the fuck too? This is how she's like, I don't understand the question, basically. Like,
File? I don't have.
You're not asserting that fact, correct?
You're not asserting that fact. You're not asserting that. What fact? I don't have to assert any fact that Bryan did or did not upload and use any of these third-party sites, because that's not my argument. And that shouldn't be the argument. And nor would I ever divulge client attorney privilege information like that. but he wants to know if she's asserting that fact. Like, are you asserting the fact or not? Are you saying that Bryan uploaded his DNA to these sites, which would then give him a privacy interest? Wait, excuse me? No.
Your Honor, I'm not sure what the court is asking me.
Well, it goes to whether or not your client has standing to complain about the searches of the databases, because as the state has posited, that wasn't his DNA that was searched. At best, it was his ancestors.
Well, Your Honor, I am not sure why we're here if the state hasn't alleged that Bryan Kohberger's DNA was on the knife sheet.
No, I'm not talking about the knife sheet DNA. I'm talking about what they tried to match it to.
What did they try to match it to? What did they try to match it to? They tried to match it in CODIS, and it wasn't a hit, right? Then they give it on over to a lab. Okay, we have no idea what the FBI did because the FBI hasn't turned over anything. So we have no idea what the FBI did. I have no idea what they tried to match it to because we don't have the information. And this is my argument. My argument is this. We don't know if Bryan Kohberger's DNA was ever uploaded by anyone at any point in time without his consent because I don't have the GEDmatch database. Based off of what the FBI did, for all we know, someone did upload his SNP at some point. We have no idea what they did. I know that the size doubled. So in that case, then Bryan Kohberger would have the reasonable expectation that Hippler is alluding to in his bullshit interruption piece here. We don't know. We have no idea. But I thought that was so improper to basically, wait, are you alleging that Bryan Kohberger uploaded his DNA to one of these sites? Excuse me? I'm not alleging any of that. Or am I saying that he did or didn't do anything? Because that is not my argument. That has nothing to do with my argument. My argument why you would be suppressing something has nothing to do with whether my client did something or not. You understand that? My client doing something or not doing something is not why this needs to be suppressed. But now you want to talk about the privacy interest. My client does have a privacy interest. My client would have a privacy interest if at any point in time his DNA was obtained and then uploaded by somebody into one of those sites, right? During this time from when the lab had it, ISP lab had it, to then when the FBI got it, right? And then for all we know, somebody could have done that. So there would have been that kid in there. You know, we don't know. So, because Hippler says that Bryan would have no privacy rights because Bryan didn't upload his DNA to those sites. His ancestors did. That's the state's argument. And so here we go. Wait, so you violated, so the FBI violated everybody else's rights? But that's okay. And the argument is, for me, is that when the Constitution was made, nobody could ever imagine 1,000,000 years where we would be with technology right now. Okay. And Ann Taylor's argument is that we're eventually going to lose all of our privacy due to technology. That's where this is heading. That we are going to have no privacy interests. None.
Your Honor, I would answer it this way. The way that those databases work is looking for shared DNA. But those databases don't turn out a name and say this is
I have a
suspect.
privacy interest against any of my relatives that might want to upload.
No, I have a privacy interest, Hippler. I have a privacy interest in that the FBI isn't violating anybody's rights. Okay, to then somehow be able to get to me. But I also have an interest in, because nobody knows who that belonged to at the time that it's being passed from Ortham, or from the gathering of it, the gathering of the sheath, to then the processing of it at the lab. of ISP, then ISP sending it to then Ortham, right? And then nobody knows whose this is. Nobody knows whose this is. But it's discarded and it's abandoned, right? So that's why they can do whatever they want with it. I would say to a point. But no, I don't. I think that when you're not explaining and showing what you did and that you can document it, from once the FBI would have got it to then upload it as then you're acting like it's your own. So I think that I do. And all of us would have a privacy interest in the fact that the FBI was claiming that it was their own DNA. Because if you are a law enforcement agent, you have to disclose that to the GGG services, and they did not. So they were acting then as if that was their SNP when they uploaded it. And that to me is, well, that seems really strange. And why would the FBI do that? Why wouldn't they just follow the policy? Well, because everybody knew at the point that Ortham couldn't get the connection, they knew that they did that within following the guidelines. But here, in order for us to get to where we got, all right, we have to violate our own policies. So then I asked myself, okay, how would I feel about, all right, I get it. You're going to use where people are, hey, everybody's putting in their DNA. Well, if there's people that opted out of being used for the law enforcement purposes, and if one of those people were used, then how isn't it a violation of not only the policy, but Americans, period? Because I think the way that this needs to be looked at is it's our rights. Like Bryan Kohberger's rights, that could be me on trial. But I think that you going and uploading a profile in SNP and acting like it's yours, that's fraud, right? It didn't work this way by us following the rules. And now we're going to go ahead and give it to the FBI. And somehow once the FBI gets it, it doubles in size. And then the FBI uploaded it. But we have no idea if the FBI how about this? Why did they send it to the FBI in the first place? What was the reason that they sent it to the FBI? If your lab, that's one of like the best, says that, let me tell you why I believe. Because you're knowing that you're about to violate the policy. Why else would you send it to the FBI? How can the FBI do it any differently than you would have done it? We uploaded it to the ones that we can use, and the ones that we can use, God, there's nothing here. Okay, so then if we send it to the FBI, they have the people that are willing to use the sites that are against being searched because we opted out.
Their DNA to one of those systems, I should be able to stop them from doing that because I share some DNA.
That's not the argument.
That is certainly not what I'm saying. What I am saying
Thank you.
is if somebody takes your DNA and uploads it, I think you have a privacy interest in your own DNA. If
Not necessarily in, let's say my DNA is taken lawfully.
Right there, if your DNA is taken lawfully, okay, what do you mean by that? How would your DNA be taken lawfully?
What privacy interest do I have in the search of the DNA of others?
When you upload it, sir, when you're uploading it to these other sites, you can go ahead and do that. But what we're saying we have a privacy interest in is that if you don't have policies in place and you're not following your policies, but here, I wouldn't have even argued it. I'm sorry, I just would have went differently with how Ann argued it. I would have argued the fact that why would the FBI need to take over anyways? What would be the purpose? And who needs to sign off on that? And so what could the FBI do differently that Ortham, oh, hey, Ortham's not doing it right. Send it over to us. We know what we're doing. Send it over here. You get what I'm saying? But Ann Taylor's not going to argue her case now. So she's being very careful. And people want to say, like, Ann Taylor didn't know how to say this. Ann Taylor's smart as fuck. She's not arguing her case here. I'm not arguing my case in terms of when these people come and take the stand, like the Bill Thompsons, like the lab manager of ISP that sent it to Ortham, and then Ortham's. Who trains the FBI people? The Gabrielle Vargases of the world and the CC Moores of the world, right? They're the ones that are training those people. And they're the ones that knew about the loophole, as well as using databases that aren't allowed. And the only way you can do that is act like it is yours and that you are uploading it as a consumer and not law enforcement. And that is 100% against this policy. And so we do have an interest in the government, we do have an interest in the government thinking that the rules don't apply to them, right? I have an interest in that. Let's say that a kid uploads it who's not 18 yet and I'm their mom, right? And then let's go say that I commit a crime. You just violated my kid's rights, right? To get to me. Do I have an interest in that? I'm the only one that can sue on behalf of my kid that you just. So I think I have a problem with the FBI uploading to sites and acting like it's their SNP. It's fraud. And you would be frauding everybody that you're then going to compare it to because you're claiming that that's yours and it's not yours. And then when you want to talk about the information that the SNP has in it, if you choose to go down a route, because when does it stop then? Because then you just take it and then you can start getting genetic information as far as like this person has this disease, this person has that. It's going to be a ripple effect like you wouldn't believe. So the interest that we have as Americans, that's why that they didn't want to show that beginning part. And all we got to hear is this little argument here. The issue is in how you're doing it. Okay, that's the issue that I have. How you're doing it. And if you're just, and they knew when they sent it to the FBI that the only way to get more matches is to violate the policy. And that tells me that you had intent to violate America's rights. And so when they want to say, how does Bryan Kohberger have an interest in other people's DNA? Because I think that you could make the argument of what if Bryan Kohberger's DNA was in the database? Then that's the only way that's the only way it becomes a violation, Hitler. That's what his argument is that I could see if Bryan Kohberger at one point in time uploaded it, and then they would be violating his rights. So let me tell you what everybody needs to go and do. You ready for this? Everybody go and upload your DNA to these third-party sites, and then you're always protected. If you're a criminal, go and upload your profile. You hearing me right now? Based off of what Hitler just told everybody, go and upload your profile if you are a criminal. And it's going to protect your rights. And that's absolutely absurd. But hey, you want to play? We'll teach you how. There you go. But so go upload your DNA. Think about that. That's his argument. Well, are you saying that Bryan uploaded his DNA? Because if Bryan would have uploaded his DNA, then it would be a violation of his privacy rights. Think about that. And for me, it's not even if Bryan did it or not, because what if he did do it? It's the potentiality that he could have, right? And then if he could have, like, you don't know whose rights you're violating. For all we know, the people that were connected to Bryan, who knows if they were the ones that ever uploaded their own. We don't even, for all I know, my snip could be in there because somebody uploaded acting like they were me, because for whatever reason they wanted to see if they were related to me, because they think that their parent had an affair with my parent. So here, let me go ahead and take my friend's DNA stuff. I'll upload her kit, then I'll upload my kit, and that way I can see if we're truly related. So Bryan, in my opinion, has no idea. Woo! But for me, listening to Hitler insert that question was absolutely improper of him to ask of Ann Taylor, because in a sense, to answer that question, she would have had to violate client-attorney privilege. You understand that? And that's, I mean, I would be irate if I was Ann Taylor. How dare you ask me right when the cameras come on and right when I'm in a flow of going through all of my shit, do you think that you have the fucking cahoons to disclose in this courtroom client attorney privilege information? Who do you think you are? You want to play swing game, Hitler? I'll play swing game with you all day long. And I hope Ann Taylor hears this, because I want someone to tell me that I'm absolutely crazy for that. For me saying, well, how the heck was he saying that? Go listen to the question. He's asking Ann Taylor if she's implying that Bryan, basically, Bryan, what did you do? Did you upload your DNA or not? The fuck? You're asking me to disclose that information. Well, I would think that you're asking me to violate client attorney privilege. And as a tribunal, for you to even do what you just did there, go look up the codes, the ethic codes, and I think that that's a violation. So fuck you, Hitler. That's what I think. So you want me to play these games of technicalities? We'll play them all day. Okay, because I will out-research anybody in here. Exactly. And AT, she didn't take the bait. She didn't. And she was very, very cautious of how she was answering things. And that's the sign of a very good lawyer, especially when you're playing with somebody that plays mind games up here. I don't know who this guy thinks he is. I don't care if he's a judge or not. Show some damn respect. And why are you cutting people off? Like, they're oral arguing at the end with their summaries and whatever. But that question had zero bearing, was so irrelevant. Because it doesn't matter. But if you want me to twist it, basically what you just said, Judge Hitler, is that if Bryan did upload it, he then would have a privacy right, and he could lodge it, and then it would be thrown out. Well, I think for the simple fact that if he would have is enough to say that, yeah, you can't be the FBI. You just can't be going and uploading and acting like that DNA is theirs. I think I have a privacy interest in that. Because they're doing that, it could eventually, and it did in this situation, it will always because who's ever going to be sitting in that chair, it will always have impacted that. When it's not done the right way. When you do it the right way, it's done the right way. So anybody would say, oh, Lana said that you can never use this. No, you can use this. Ortham did it right. That first level of chain, that was done correct. It's when it went from ISP's Ortham lab that they contract with, from that point to the FBI, that's when everything went haywire. And it's because the FBI thinks that they can just do whatever the fuck that they want. And by God, Donald Trump's here to say, no, the fuck you can't, motherfuckers. This shit's over. The days of you doing this shit are done. And they're going to dismantle the fuck out of the FBI. And I'm here for it. And so, like, I'm also here for I want some of my tax money back. I'm also here to see the new the JFK declassification of MLK files. JFK. I love that he's going to give RFK the pen that he signed it with. Okay, like this is enough's enough. Like we're not going to have any. We need to keep our rights intact, you guys. And we no longer keep file cabinets at home that have our personal medical shit in there. Those days are over. The way that we live is completely different from when and what, like the people writing the Constitution. So there is going to have to be case law that is going to have to start happening. And so some of these judges are going to have to pony it up. Okay. And this right here, if the FBI would have done it right, awesome. But for me, it's the intent. When you read this policy, and I've gone over on my show, and that's how I knew that Bill Thompson knew way more, and he's a fucking witness. He's a witness. Bill Thompson had to make every decision on every time that SMP was being pushed and moved. And he had to be contacted the whole way. And then he had to, since Moscow Police Department has the jurisdiction, and they never gave it up, Hippler asked, well, so should the FBI burden the state? Fuck yeah. Because the FBI was basically working for Moscow Police Department. They were working for them. They didn't have jurisdiction. Never once. So, there had to be a lot of consulting going on here. And every decision had to be passed by the prosecutor. And so Bill Thompson, when he would get up like Santa Claus and scream and yell in those hearings, looks like a fucking fool if you actually read the papers. And all Ann Taylor's saying is that the argument is we have no idea, Hitler, what the hell they did. Because we don't have it. But I can tell you this. When it was done lawfully, it came back as there was nothing there. There would have been nothing to compare to. And then Hitler wants to say right here, well, what did they compare when they went and got the samples? Well, what did they compare? Why would the FBI or Moscow Police Department ever go to a random house in Pennsylvania and go and get the trash? You fucking idiot. Do you know how many people live in America? Why would they ever go and get that man's that trash? And just take the whole trash, and then what were they testing? To compare it to what? Well, this interim policy says that if you're going to use a biological sample because of your FGGS measures, then you must get a search warrant. So I don't know how you're going to get around that part of it once you use that trash, because that's right here, and it's in Section 7. And you could say, Alana, you're interpreting that wrong. Okay, well, I'm making a very good argument for it because I'm using what the word biological or of the sample, the number 12 here. It's a forensic sample is called, in definition, is a biological matter reasonably believed by investigators to have been deposited by a putative perpetrator that was collected from a crime scene a person, an item, or a location connected to the crime, to the criminal event. And for purposes of this interim policy, the term forensic sample will also include unidentified human remains of suspects in a homicide investigation. So that 100% falls under that, going and getting that trash and any biological matter, material, which be reasonably believed by investigators to have been deposited by a perpetrator. So that does meet that definition, because otherwise, why are you taking that trash? You had reason to believe. And that most certainly, if you are doing FGGS, you need a warrant. And it doesn't say you should, it says number 7 here says, after consulting with the DLO, which is the designated lab, the investigative agency shall contact the prosecutor. The investigative agency shall advise the prosecutor of the nature and status of the investigation, the results of the DLO's evaluation of the candidacy for forensic sample, which includes the size. So Bill Thompson would have, and any reasonable scientific alternatives. So Bill Thompson is being told all of this, and so is Moscow Police Department. If you are going by the interim policy. So for the FBI to have had that sample and identified stuff and not turn that actually over to Moscow Police Department immediately, that information, what the fuck are you doing? And that's why the defense is saying, Mr. Kohberger has an interest in knowing what is the FBI running around with his DNA for? Because the moment that they would have identified Mr. Kohberger, you were notifying the prosecutor and the investigating agency that has jurisdiction. And it was not the FBI. The FBI did not have jurisdiction in this case. So I would be arguing jurisdiction, that everything would have had to go through MPD, at every phrase. So for them not to know about Bryan Kohberger's name until December 23rd, what the fuck? How is that even happening? All right, let's go. We're probably going live here. Let's see if the case is starting. What time is it? All right. So that's how I wanted to start it off, to say is anybody that thought Ann Taylor didn't do a good job is absolutely out of the rocker. Ann Taylor rocked it. Ann Taylor didn't cough up client attorney privilege when Hippler attempted to get that. So.
Present, represented by Mr. Thompson. Mr. Nye, Ms. Jennings. This morning's hearing will discuss the motions to suppress and any evidence related thereto, as well as we'll get into the argument on that. So with that, I understand the parties are prepared to proceed. The defense, do you have witnesses to call this morning?
We do, Your Honor. We have 2.
All right. Who's your first witness?
Corporal Brett Payne.
All right.
Woo! All right, massive.
You were sworn yesterday, as I recall, but we'll go ahead and do it again just for formality's sake.
Good morning. Morning, ma'am. Could you please state your name and spell your last for the record?
Brett Payne, last is spelled Payne.
And what's your title?
I'm the Detective Corporal for Moscow Police Department.
Can you tell the court, I know you testified yesterday, but it was a different hearing, and so just to lay a little bit of foundation, can you tell the court your background in law enforcement?
So I've been with Moscow Police Department for almost 7 years now. Prior to that, I was in the active duty military for 6. 3 of those were as a commissioned officer in the military police corps.
What is your role in this case?
I was assigned lead detective in this particular investigation.
And so, as lead detective, can you explain from your perspective what that has meant that you have done?
Certainly. So it was my responsibility to basically view this investigation from a 30,000-foot view, if you will. Directly, it's the teams that were assigned to various tasks, and then taking all that information, synthesize it, put it back out to our group, and then eventually consolidate it into an affidavit.
And in terms of that affidavit, yesterday there was some discussion and testimony about that and how it was created. Would you explain that?
Absolutely. So the information was brought to us via various teams and specialists in their particular areas. For instance, most of the cell phone stuff was covered by Special Agent Balance from the FBI. All that information was brought to the team, relayed back out at least twice a day. And then as that information was essentially synthesized, it was put into a running document, a living document that is now known as Exhibit A.
So when it was characterized yesterday as a group effort, do you agree with that characterization of it?
Yes, ma'am.
And do you know approximately how many warrants you worked on in this case?
I don't, ma'am. Several. I don't know the exact number.
Right. I'm going to walk you through several segments of different warrants, and some of this may seem choppy, but I'm going to try to do you and then Detective Mowry at once instead of bringing you back and forth. Does that make sense?
Yes, ma'am. Sounds good.
All right. And Judge, I have paper exhibits for you and for the witness. And so I'll go as fast as I can, but I want you to be able to look at what he's looking at. So we're going to begin with the first AT&T warrant. Prior to this case, had you ever secured an AT&T warrant?
No, ma'am. I don't believe I had.
And so, given that, who did you rely on in creating the warrant? For
Largely
AT&T?
Special Agent Balance. Obviously, he's the CAS expert, so I relied heavily on his input.
At the time that AT&T warrant 1 was secured, were you co-located with Special Agent Balance?
I believe so, yes.
Can you, well, in terms of being more specific, it was December 23rd. Were you two co-located at that time?
I believe so, yes.
And I know co-located has been talked about in court a couple of times, but can you just explain what it means for you two to be co-located since he's from DC?
Certainly. Yeah, he was in the same building as I was, just mere feet away from the command post.
Okay, so when you say mere feet away, were you guys in like a cubicle setting or were you in offices with doors? What was this setting in terms of proximity to each other a few feet away?
Yeah, separate offices with doors, but in the same second floor of the Moscow Police Department.
Are you aware of Special Agent Balance in his work in doing AT&T records, having any access to AT&T records without a warrant?
I am not aware of that, no.
Are you aware of him having any ability to review AT&T records through any portal without a warrant?
Not to my knowledge, no.
I'm going to begin with what is known as State's Exhibit 1 attached to their objection to the motion to suppress AT&T warrant. And Judge, for today's purposes, what I'm doing is relying on the labels that are in the record as opposed to giving them new stickers.
This has been marked previously as States S1, or is that 8-1? I can't.
I think it's SS for State 1.
All right, States S1 affidavit for search warrant.
And now I've got to get
Objection to the admission of that for today's hearing.
You know, Judge, I should have started out by saying that the same stipulation regarding the admission of all exhibits applies today.
We do need the formality of moving for the admission, however. So that's why.
I can do that. Do you want me to do that per exhibit?
Well, it makes, as you're talking about them, it probably makes sense.
Okay, I've got to get myself S1. Okay, Detective Payne, can you look at page 5?
Ma'am.
On page 5, can you read what it says in the at the very end of the page in the sentence above wherefore that begins with the paragraph? It begins in support. Can you read that paragraph?
Certainly. In support of the assertion as to the existence of probable cause, the following facts are offered based upon personal knowledge of affiant. See attached statement of Brett Payne, which is marked Exhibit A and incorporated as though fully set forth herein.
And is that S1 the affidavit in support of the search warrant?
Yes, it is.
And that's the AT&T 1 search warrant that was the first one served on December 23rd, correct?
That's correct.
And that language that you put in there, Exhibit A, is incorporated as though fully set forth herein. Is that the language you just read?
Yes, ma'am.
All right, I'm now going to hand you State's Exhibit 2 to the AT&T first warrant. Can you review that first page, the first paragraph?
Of S2.
Pardon?
Are you seeking the admission of S2?
I am seeking the admission of S2. Just to be clear, Judge, all of these that I'm putting before him and the ones that are attached, we're seeking the admission of.
Objection to S2. All right, it's admitted.
Have you reviewed that, Detective Payne? Do you see that the language that I just referred to in the search warrant affidavit, do you see that same language in this warrant in where you incorporate the affidavit, incorporate Exhibit A into your, you see that language in S2? And is S2 the actual search warrant for AT&T?
Yes, ma'am, it is.
Can you turn to the last page on page 4? What time was the warrant served?
10:03 a.m.
Do you recall that the return on that warrant came in at 3:30 that day?
That would sound correct. I don't remember specifically.
Would it help if I showed you the AT&T mobility propriety front page to verify?
Yes, ma'am.
Judge, I'm not seeking the admission of this, just for purposes of him being able to be certain. Sorry.
The witness may be shown the document to refresh his recollection.
Yes, Your Honor.
And Judge, for the record, this has also been admitted already in Frank's D17, page 634. Detective, can you see on that that came in at, I think it's 1530? It's
1531.
okay. Thank you. I'm now handing you Defense Exhibit A to the reply to the AT&T suppression motion.
This doesn't have a sticker on it.
Pardon?
This does not appear to have a sticker on it.
No, it does not, but it is attached to the reply as Exhibit A, AT&T. And that reply is, okay. Can you see line 4 there? Oh, sorry, Judge.
Copy and put, let's just, do you have a number that we were going to call this?
I would call it Exhibit A to reply, because that's what it is in the record. You see at the bottom of the page where it says Exhibit A, AT&T?
So this is the return of the warrant of S2?
Yes.
All right, let's call it S2.2. Or 2.1, pardon me.
That's fine.
The fact that it's associated with that particular warrant. Allowed to touch stickers under the union contract, so why don't you give it to the bailiff?
Detective Payne, on page 2 of that Exhibit A, it's actually just the front page where it says affidavit of Brett Payne. What does paragraph 4 say?
Paragraph 4 or line 4?
Line, well, 1, 2. Line 4.
It says the warrant was served on 12/23/2022 by email, fax, etc.
So do you know exactly what method was used?
I don't remember.
Okay. And it says warrant in that line, right?
Yes, ma'am.
Does it say anything about the affidavit in support of search warrant accompanying the warrant?
Oh, ma'am.
On the next page, the receipt and inventory of warrant, do you see that?
Yes, ma'am.
Can you look at description of property? What does that say?
It says 509-592-8458.
Can you explain how that's a description of property and what that means?
It just means essentially that there was the information retrieved as a result of that phone number being queried with AT&T.
And it indicates that that was produced how?
Entrance was obtained by email.
And when that was received, did you do anything to verify that the data was within the date ranges of November 12th to November 12th to November 14th of 2022?
I don't remember. That information was provided to Special Agent Balance as soon as it was received.
Do you have, when you say that it was provided to Special Agent Balance, is that because you don't have the capacity, technical skills, I guess, to review that raw data and do something with it?
Yes, ma'am.
Was there anybody else that you relied on for that other than Special Agent Balance?
Not that memory brings to mind.
Let's now turn to the AT&T2 pen trap and also known as pen trap and trace. Can you explain what a pen trap and trace is?
So pen register, best of my knowledge, now granted, I am, as I've stated before, I'm not an expert in cell phone stuff, but best of my knowledge, a pen register tracks incoming and outgoing phone calls, text messages, so on and so forth. And then the trap and trace is the portion that essentially gives you location data, or the precision data, precision location data rather. So it's essentially incoming and outgoing calls, what messages are received, and then part of that was where that phone was located when it was doing it.
Was it required that you secure the AT&T first warrant to obtain the second warrant that included a pin trap and trace?
I don't believe it was required.
So when the data was received on at 3:30, you gave that data was given to Special Agent Balance?
Yes, ma'am.
Okay. And then what happened in between 3:30 and 4:53 when the second warrant was secured?
Are you talking technically speaking, or can I speak in generalities? Because that's all I really know.
Well, I want you to talk about what you know.
So the only thing I know is that that information was provided to Special Agent Balance. He utilized whatever tools he has at his disposal, and then it was decided upon to go after the second pin trap and trace.
When did you start drafting that second trap and trace?
I don't remember.
So on that day, you did one in the morning that was secured at 10:03.
Yes, ma'am.
And then the second one was secured at 4:53 p.m. And you don't have a recollection of when you were working on those?
I don't remember, no.
All right. I think you have State's Exhibit 2 in front of you.
Yes, ma'am.
Can you flip back to that one? Can you see on page 1, what does it say that the time of that warrant was obtained?
Talking about State's Exhibit 2. Oh, 10:03 is what it says. Is that what you're referring to?
No, I'm referring to the return, which should be in, I might be referring you to the wrong exhibit.
Point 1, I believe.
And that was at 4:53. The second warrant was obtained at 4:53. I might not have handed you pin trap.
I don't think I have that one.
Yeah, my understanding is, just so we're clear, because I'm getting a little confused, is that we have the affidavit for warrant, the warrant, and the return of the warrant all related to the first warrant to AT&T. And we haven't got the pin trap and trace warrant presented yet, I don't think.
Right, I've got it here. And Judge, for clarification purposes too, today as we're going through testimony, my plan was not to go through every single warrant that we're arguing about and get it in front of the court. I'm really trying to take kind of a scalpel approach on the issues that we want to point out to the court. So it does really feel like I'm jumping around, and I realize that. I hope to bring it all together in the end.
The only caveat being what I've told you before is where you have is a broad array of documentation that you've presented. The court will not scour the record to find support for your motions that's not pointed out to the court specifically. And that's well established with case law from the Idaho Supreme Court.
And Judge, that's why I am trying to grab the pieces and parts that I want you to be able to identify, and that's why I'm putting the paper in front of you. So I'm hearing you when you've asked us to do that. All right, I'm handing you State's Exhibit 1. And this is to the second AT&T warrant, also known as Pen Trap and Trace.
This one is also listed as S1 on the sticker. So that's going to cause some problem, I suppose.
It's S1 attached to a different motion to suppress.
Well, hopefully we can figure it out when we're looking at the entire record. But
Yeah. And what I think, Judge, when you are going back and working with your clerk.
my concern, frankly, I know what all the documents are and what they relate to.
Yeah.
My concern is a reviewing court's ability to understand what you're talking about in court today and trace it to a stack of documents. That's my concern for this. So.
And I understand that. And so in preparation for today, I mean, I really did think, do I need to go through and label all of these? And I thought that would create more confusion in the record because these are all attached to specific motions with these labels.
This is marked S1, titled Affidavit for Search Warrant and Application for an Order for Pen Register or a Trap and Trace Device.
Yes.
So you're on the record what we're looking at.
So Detective Payne, is that the warrant that, that affidavit in support of the search warrant that you drafted for that second AT&T warrant?
Yes, ma'am.
On page 11, at the bottom of the page, can you read that last sentence under probable cause?
Certainly. In support of the assertion as to the existence of probable cause, the following facts are offered based upon personal knowledge of the affiant. See attached statement of Brett Payne, which is marked Exhibit A and incorporated as though fully set forth herein.
All right, I am now handing you S2, which is the search warrant and order authorizing installation and or use of pen register trap and trace device and non-disclosure order pursuant to Idaho Code 18-6772. Can you please turn to page 7? Can you see what time that was obtained?
4:53 p.m.
I'm now handing you what is titled Return of Search Warrant, Exhibit A to Trap and Trace.
Does that have a sticker on it?
Pardon?
Does that have a sticker on it?
No, it does not.
It's 2.2.
What'd you call that, Judge?
S-2.2.
S-2.2.
Further delineated by the title, which is related to the pen trap and trace.
On page, can you look at page 2? You see the top, who does it say it's the affidavit of?
Corporal Brett Payne.
Are you looking at Exhibit A, page 2?
Oh, correction. I see what you mean. Affidavit of Lawrence Mowry is what it says at the top.
Right, and then, but is that actually your
It is. Yes, ma'am.
affidavit? Okay, so that was a mistake.
Yes, ma'am.
I'm sorry, what were you looking at?
On page 2, the top of it says affidavit of Lawrence Mowry.
Oh, gotcha.
It's the affidavit of Corporal Payne.
A heading problem there.
I'm now handing you Exhibit C to the reply to Trap and Trace. It does not have a sticker. And it says AT&T Mobility Carrier Request Form.
This again relates to the trap and trace warrant.
It does.
Let's mark that S2.3. In the next day or so, if you would provide a formal identification list, if you will, of the exhibits that you'd stipulated to admission to yesterday, as I don't think we went through those individually, just so that there's a record of that.
We can do that. Might take us a couple days, but we can do that. Can you look at, are you looking at that Exhibit C, Detective? Was cell site location data requested for this warrant on this page?
Yes, ma'am.
And was a timing advance report requested on this page? I'll refer you to the last paragraph where it says remark special instructions.
Yes, ma'am.
And do you see any reference in this document indicating that the affidavit in support of search warrant was included with the warrant?
No, ma'am.
Okay, the next warrant I want to talk about is Apple.
He said no. Welcome to the transparency. Come on in, make yourself known. Come on in.
Prior to this case, had you ever prepared an Apple warrant?
I don't remember.
What was your training related to Apple warrants in December of 2022?
I had no official training at that time.
I'm handing you what's been marked as Defendant's Exhibit A. It does have a sticker, and it's to the Apple motion.
No training from Apple to do warrants. No training from anybody to do an Apple warrant. He's never been trained to do an Apple warrant.
Can you state what that document is?
Appears to be a preservation request.
And who is it sent to?
Apple Corporate Legal Counsel.
And what's its date? What is it? What is the date on it?
December 21st.
Of 2022.
Correct.
And that letter was not sent by you, right?
No, I do not remember sending this. No.
Well, can you look at
That's not me.
Yeah, the top of it is Department of Justice, and the back page 2 is Special Agent in Charge Dennis Rice.
Correct.
How was the DeSales email account known at that date?
I don't remember.
How did you become aware of an Apple product in this case?
Memory serves, when the search warrant in Pennsylvania was executed, there was an iPad that was located in one of the shared living spaces in the home. And there's a receipt in his vehicle, in Mr. Kohberger's vehicle, that was found for an iPad as well.
And during the home search, was the iPad seized?
It was not.
Why not?
It was in a shared living space.
Do you remember what day that the Apple account was created?
I don't remember. No, ma'am.
Does 2016 sound familiar with the research?
That sounds vaguely familiar. Yep.
And you mentioned the receipt that was found in his car. Do you recall the date that indicated that an Apple product was purchased?
I do not remember.
Right. I will show you State's Exhibit 1. To the affidavit for search warrant.
I don't even know that answer.
It's tabbed, the receipt.
This is State's Exhibit S1, affidavit for search warrant to Apple Inc.
And it's 2018, the date.
Yes, ma'am.
Where did you get the form to prepare the Apple warrant?
The form? Be more specific?
Correct. The search, so you're looking at the search warrant affidavit, and inside of that affidavit is a long list of items that you request.
Yes, ma'am.
Where did you get that information to be able to include that?
That was all provided to me from the experts in that particular field.
I'm just getting S1 in front of myself for a minute here, Judge, so I don't, or I'm gonna have to give them a different exhibit.
Just so I'm clear, are those when you said the long list, are you referring to paragraph B on page 2?
On page 2, beginning on page 2,
Is that what you're referring to?
I'm referring to everything A through I.
I'm sorry, was there a question pending? I kind of threw us down a side alley there, so I apologize if there was a question pending that I threw you off from.
No, that's fine. I'm looking for the page. Here.
Well, let's bring it. Woo! I mean, Payne has answered, I don't know. I have no training. I have never filled out an Apple warrant. I've never filled out an AT&T warrant. He's never had to fill out an AT&T warrant in 2 years of being a cop at Moscow Police Department with all
Do
those
you recall
deaths.
that in your affidavit, there's reference that iOS devices can use an iCloud account to back up the iOS device?
Yes, ma'am. That sounds familiar.
And what is it? What's your understanding when an iOS device uses an iCloud to back it up?
Similar to Google and many other of these digital operating systems, essentially they back it up to a cloud account. That information is stored not on your device only, but also in a cloud storage area. That's my understanding of it.
And so in an Apple phone, that ends up as creating a duplication of what's on the phone?
Essentially, yes.
And do you recall that in the affidavit, you made reference to the fact that Apple users get 5 gigabytes typically of storage and then can purchase more?
Yes, ma'am.
I'm handing you what's been marked as Exhibit D to, it's Defendant's Exhibit D to the Apple memorandum in support of suppression, and it is it does have a sticker.
All right, it's marked Defendant's Exhibit D, date 11/14/24, entitled Affidavit for Search Warrant, directed to Apple Inc.
Can you please turn to page 27?
The actual warrant itself that you're.
Yes.
Yes, ma'am.
I don't want to answer that as a yes before I look and make sure what this exhibit is.
I want to make sure because my page numbers run out at 25.
It's Exhibit A, and it's to the Apple warrant. It says, so Exhibit D, Apple at the bottom, that page says page 27, but above that it says page 23.
I'm there.
Okay. At the top, it says on January 27th, Apple Inc.'s Privacy and Law Enforcement Compliance Office responded with the requested record.
I'm not there, so can you?
Oh,
give
I'm
me some
sorry.
direction? Are we looking at
Exhibit D?
D?
Yeah, page 27 of my marking bait. So it says Exhibit D Apple page 27.
On January 27, 2023.
Yes.
All right.
Yes.
Go ahead.
On January 27th, 2023, Apple Inc.'s Privacy and Law Enforcement Compliance Office responded with the requested records. Can you explain what Apple responded to?
I don't remember what all they responded to. They responded to the search warrant and all those listed items that were in the warrant itself.
And the warrant, the date on this, if you will turn to, let's see. Turn to page 34 of the exhibit. Do you see the date of the warrant?
1st of August.
So I understand that you just said you don't know or you don't remember, but in this context, in your search warrant affidavit, you make reference to something being produced on January 27th to process to get a warrant in August on August 1st. Do you know what the process was that Apple responded to or what they produced?
I do not remember. No, ma'am.
What? August.
I am handing you Defendant's Exhibit B to the Apple Defendant's Memorandum in Support. It does have a sticker on it.
All right, the exhibit, just for the record, is Defendant's Exhibit B, date 11/14/24 on the sticker, and the title is Certification of Apple Inc. Custodian of Records.
Detective Payne, on this, there's a certification. This document is a certification of Apple Inc. Custodian of Records. Do you see that?
Ma'am.
And it indicates that records are certified and being produced from legal process served on to Apple on January 12th, 2023.
Yes, ma'am.
You see that? What was served as legal process on Apple on January 12th, 2023?
I don't remember.
You know what the legal process would be?
I don't remember what that would have been.
Going back to Exhibit D. Do you have that one in front of you still?
Yes, ma'am.
You can't question somebody when they don't know.
35 of that.
Like, I don't know. Every answer is to say, I don't know. I don't know. Well, how did you get any of this?
On line 4, what does it say?
Warrant was served by Corporal Payne on August 1st, 2023 via law enforcement at apple.com.
And so that would have been the Apple warrant, right?
Correct.
And you served it, right?
I believe so.
Well, when you say you believe so, would you have executed an affidavit if you hadn't?
No, ma'am. I just wanted to make sure on the warrant return itself that it wasn't served by one of the digital forensics folks.
This affidavit is your affidavit, and on line 4 it says you served it, right?
Yes, ma'am.
Did you serve that with a copy of the search warrant affidavit?
No, ma'am.
Was it your practice in serving all of these warrants that where you actually did service that you would serve the warrant only?
Yes, ma'am.
And then on Exhibit D, page 37.
Okay.
At the bottom where it says description of property, can you explain what the return was for that Apple warrant?
All account information associated data for the following Apple identifiers, and it goes through DSID, Apple ID, B. Kohberger at spartan.northampton.edu, another DSID, and Apple ID, Wi-Fi Army owns at yahoo.com.
Did you open up the Apple data and examine that?
I don't remember if I looked at what the return, like all the files that were attached were.
in terms of evaluating that Apple data, as the lead investigator, who have you put in charge of evaluating Apple data?
I relied on the specialists in those fields, which would be Detective Mowry and then S.A. Balance. Those are the folks who knew far more about it than me.
And do you know, as we sit here today, whose job it is to evaluate the Apple data for this case?
I don't know, ma'am. Not right now.
What the fuck?
The next warrant we will talk about is Google. I'm handing you what's being marked as Defendants D to the Google memorandum in support of suppression.
Right, so that I'm clear and the record's clear, this is Defendant's Exhibit Number D with the date on the sticker of 11/14/24, which refers to the sticker date, I believe, not necessarily the document date. And then it's entitled Return of Search Warrant, the warrant being with respect to the application of search warrant for Google LLC. That as the other documents that were proffered are admitted.
Did you prepare the Google warrant returns Exhibit D?
Yes, ma'am.
On page 2 of that exhibit, does your affidavit say Detective Mowry served the warrant through a portal?
Yes, ma'am.
How did you know that?
Told me that.
When did you get the return? When you got the return, did you review the data?
I did not, ma'am.
Did you take any steps to see if the return conformed to the warrant?
I did not look at the technical data contained within. I believe it was a zip file that was downloaded from Google, if memory serves me correctly. I downloaded it and made sure that that was there.
And do you recall that there were actually 3 Google warrants? Does that sound familiar? I'm going to hand you now Defendant's Exhibit E. The Defendant's Exhibit E to Google memorandum in support of motion to suppress.
All right, Defendant's Exhibit Number E, again with the date on the sticker 11/14/24. This is a receipt and inventory of warrant to Google.
On this document under the description of property, can you state what Google account you put in as received?
Zip files for all digital records for the Google accounts of Bryan Christopher at gmail.com and username spelled a bit different at gmail.com.
Did you know that the email in the warrant is actually Bryan Christopher 1994 at gmail.com?
That sounds familiar. Yes, ma'am.
So on that description, is that a mistake?
Yes, ma'am.
And did you do anything to, I asked you this, but you didn't do anything to verify that the data that you received from Google fit what was requested in the warrant?
No, ma'am. Not to my recollection.
That's it for Google. You were in Pennsylvania for Mr. Kohberger's arrest, correct?
Yes, ma'am.
And you watched the preparation for service of the arrest warrant?
How do you mean?
Well, maybe I should ask this more open-ended. Tell us about your arrival in Pennsylvania in time-wise to his arrest, time frame of his arrest.
I believe we arrived there, if memory serves, about 7 p.m. on the 29th. And I think I get my dates right here. We observed final preparations for the SRT operation that was going to take place. And then we being myself and Detective Gilbertson from ISP, drove to a separate Pennsylvania State Police barracks to await the arrival of Mr. Kohberger.
When you were observing preparations, what were you observing?
I believe we observed their final tactical brief for SRT, and that was about it.
Can you explain what that was like, what the preparations were that they were making when they were doing that tactical brief?
I can give you a general overview as best I got. So they had their entire SRT that was going to be conducting the operation present.
For the record, SRT is
A special response team, usually what it stands for, Your Honor. So they were doing their final preparations, going over their approach, team member assignments, so on and so forth. This was all done via basically a briefing in front of everybody.
And do you recall that the preparations included that in preparation they were going to knock and announce in execution
I believe that was brought up. Yes, ma'am.
of the warrant? Okay. And while you were there, did you go into and have were you given a tour, or did you drive into the gated community of Mr. Kohberger and see where he was living?
No, ma'am.
You never went in or around his home?
No, ma'am.
When the execution of the arrest was happening, did you have the ability to listen in any way?
The only ability that we had at the time was a very choppy drone feed. We were driving at the time it happened, and that was the only communication we had.
And so how is that choppy drone feed being communicated to you?
Via cell phone.
So can you explain that? Like, who's the person communicating with you about the drone? I just don't understand.
So essentially, it's a drone operator with their SRT. I don't remember how it was conveyed, a link of some sort. They dropped a drone, it took off. I got the link so we could essentially just watch a live feed of what the drone was seeing, and that was it.
Do you know if that live feed was recorded?
I do not know, ma'am.
Did you record the while that was happening? Did you create a recording?
No, ma'am.
What is a Bearcat?
Bearcat's an armored vehicle used in SWAT operations.
And do you know what role the Bearcat? Describe that vehicle again.
So they're usually built on, I think it's like a Ford F-250 chassis. So it's a pickup cab essentially, but it's got a large box compartment in the back, for lack of a better term. Usually has portholes on the sides. It's highly up armored to protect the occupants, being SWAT operators. And they usually use them as an approach vehicle. So they have a covered location to deploy from.
Is it a like a retrofitted military piece of machinery?
No, ma'am.
It's specifically a law enforcement piece of machinery.
Yes, ma'am.
And it sounds like it's really big.
It depends on what you're comparing it to. I'd say it's no bigger than, if you were to have a pickup camper on the back of an F-250, something like that.
And what's your understanding of where that Bearcat was parked for the arrest?
I believe the Bearcat, if memory serves, drove up the driveway and just parked in front of the house.
It just drove up the
driveway. What's been
driveway.
marked as States Exhibit 5 to the motion to suppress, and it was attached to 119 Lambsden.
Beep beep here. Hey.
All right, this is marked with an exhibit sticker S5. Title of the document is Pennsylvania State Police. Heading with essentially a letter directed to Detective Payne.
Detective Payne, can you explain what that letter is?
That's a justification for reasoning for amending the original plan for knock and announce to a hasty knock and announce and quicker entry into the Kohberger home.
When did you receive that?
I believe this was recently. I don't remember what date.
When you say recently, was it received in response to prepare for today's suppression hearing?
I believe so.
Do you know why Mr. Lang didn't date the letter?
I have to ask him, ma'am.
And so in that correspondence, he explains that the knock and announce was shortened to announcing from the Bearcat with immediate forced entry.
Yes, ma'am.
Were you present when Detective Gilbert Mirandized Mr. Kohberger at the station?
Detective Gilbertson?
Gilbertson, sorry, yes.
Yes, ma'am.
And that took place after Mr. Kohberger was first seized in his home, right?
Correct.
That also took place after he was transported in the back of a police car to the station, right? You noted in your report that Detective Gilbertson had a recorder in his pocket at the time of the interview.
I believe so.
Were there any recordings that took place at the Kohberger home when entry was made into the house?
I do not know.
Where was Mr. Kohberger's car parked at the time of his arrest?
It was in the garage.
Was it later seized pursuant to a search warrant from that garage?
Yes, ma'am.
And when you said that the iPad receipt was found in the car, is that the car that you're referring to?
Yes, ma'am.
That is all the questions that I have for you. Thank you.
So who was in charge of this investigation again?
Cross-examination. Just a moment, Your Honor.
Oh, come on. I'll give Bill his debut.
The state doesn't have any clarifications for this witness.
I knew it.
Step down. Actually, if you don't mind, I actually have a question.
Of course.
Okay.
You testified that you didn't send the affidavits in support of search warrants with the warrants themselves to Google, Apple, etc. The persons that processed the evidence received, would they have knowledge of and access to the affidavit?
Absolutely, Your Honor.
Questions and follow up to that?
I do. How would people that are getting an email through a portal, Apple, Google, AT&T, how would they have access to the affidavit?
The question was the people that received the evidence, not the people who sent it. So in other words, the police and team that reviewed the evidence, did they have access to it? Not, that wasn't my
Okay,
question.
I didn't hear you. You do
Just
have
to clarify.
You do have a soft voice, and I am losing my hearing. But I so then based on that, how would those folks get access to the affidavit in support of the search warrant when they're reviewing materials.
Just so I'm understanding you, those folks, meaning the people who work for these companies, is that who you're referring to?
No, I think that's not what the judge was
Correct. I
asking.
understand.
He was asking that once that evidence is returned and you log it, his question was, do they have access to the affidavit in support of search warrant?
Right.
And your answer to him was yes, absolutely.
Yeah.
How?
There were paper copies of it. It was no secret. It was shared freely amongst the investigative team.
Okay. But not each person reviewing, various people are reviewing these, the electronic data for the some 67 devices and third-party warrant returns, right?
Yes, ma'am.
And in terms of my question earlier, which was who I was asking about Apple, who's reviewing that data? Your answer was, I don't know, right?
Yes, ma'am.
So if you don't know who's reviewing something, how would you know that they have access to a search warrant and affidavit?
That's the beauty of having a collaborative team effort. If you share the information freely, it's not independent upon myself to provide that to them. Everybody has that information to reference.
So is in the database that you're creating with this collective, I'll stop this, break this down. My understanding is that the collective document is Exhibit A, correct?
Correct.
And then when you attach Exhibit A to a warrant with Exhibit A to a affidavit in support of a search warrant, you also add additional language depending on who that warrant is for, right?
Correct. Yes, ma'am.
So there are over 100 different search warrant affidavits in this case. And it's your testimony that everybody who would have access to doing review of data has access to go in and look at what exact search warrant affidavit was executed?
I believe so, yes.
I have no further questions.
Follow up from the state on that. All right, thank you, Detective.
Judge, I think we don't need to step away, but I do need a break to organize my documents
Just watching.
for the next witness, who will be Detective Mowry.
Welcome. If you're just joining Truth and Transparency, hit the thumbs up, make yourself known. That is absolutely ridiculous. That is absolutely ridiculous. Absolutely ridiculous. And it's just great because, like I said, I don't care how Hitler rules on this. We, the people, can see what's going on here. Ashley Jennings was told, don't you speak today, girl. There was no rehabilitating that witness. Don't even try. Let him hang. Who has all this technology and they're doing all of these things and none of it's recorded? You expect us to believe that? Then you purposely didn't record it, but you have all these abilities. And
Defense calls Detective Mowry.
Bring his ass up here.
Be sworn. One of my staff took the opportunity to take a break. They'll be back in a second, so we'll just get them sworn in and we'll wait for them.
Do you solemnly swear affirm the testimony you're about to give now before the court is the truth, the whole truth, and nothing but the truth? I do. Thank you.
And I think it's fine if you just want to start with if you're going to ask him his background, you can do that.
Good morning. Detective Mowry, could you please state your name and spell your last for the record?
My name is Lawrence Mowry, Mowry.
What's your current job?
I am a forensic detective with the Moscow Police Department.
And could you tell us about your background in law enforcement?
I have 14 years of law enforcement experience in the state of Idaho. I've been with the Moscow Police Department for the last 6 years in this current role.
What is your role in this case?
I was, I guess, put in charge of, lead, I don't know. I was the one that was looking at and funneling the excessive amount of digital data and evidence that was coming through.
Have you taken on any other roles in this case? Have you had other duties?
If you're asking about serving warrants for digital evidence, then I've done that, yes.
And you've heard Judge Mike.
Yeah, you're fine. Go ahead.
Okay. Do you agree that the Exhibit A that's been discussed was an attached to warrants, that was a group effort?
Yes,
Have you been a part of that group?
I was.
What role did you have in the first AT&T warrant?
I don't recall specifically. I was there when it was being discussed.
I was present in the
Recall that
room.
you served that warrant?
I do.
When you served that warrant, did you serve it with the search warrant, with the affidavit in support of search warrant attached?
No, ma'am.
Is it your practice to ever serve an affidavit in support of search warrant with the warrant?
No, ma'am.
Were you co-located with Special Agent Nicholas Balance as well?
Yes, ma'am.
What was the distance that you had in proximity to him?
He sat in the same lab that I did.
And so was that a cubicle setting? Can you describe the setting?
It's a secured forensic lab. It has a door.
And then inside, is it open? Were you in separate offices?
It's a single room.
Single room. And so you were literally in the same room with Agent Balance?
Yes, ma'am.
And was that for the entire time that he was co-located there?
Yes, ma'am.
Were you aware of his ability to have access to AT&T records without a warrant?
Wow.
All right, I want to talk now about the cell phone, also known as the USB. Do you recognize that? Brian, I should say, I'm so sorry because there are so many cell phones. Bryan Kohberger's cell phone. I'm going to talk to you
The
about.
physical cell phone or the data from the cell phone?
We're going to talk about both of those.
Okay.
So for purposes of today's argument, we've called it cell phone / USB. How did the state come into possession of Brian's phone?
Obtained via the warrant in Pennsylvania.
Was a copy of that phone made prior to the search warrant being signed?
Which search
Copy
warrant?
of Brian's cell phone.
Again, I'm asking which search warrant. You're talking about the one from Pennsylvania or the one that we requested once the data returned?
I'm talking about when it was first seized. So it'd be the first.
The Pennsylvania one?
Right.
I do not know.
Oh my God, it wasn't signed
You're aware
yet?
that a copy of the phone was made and put on a USB.
Yes.
And then a warrant was obtained to search the USB.
Yes, ma'am.
And that's the second warrant.
Yes, ma'am.
Was the cell phone searched prior to the warrant for the USB?
The extraction was created before the warrant in Idaho was requested.
Was the extraction searched before the warrant was obtained in Idaho?
No.
And how do you know that?
Oh, God.
I was the one that received the extraction.
Okay, so you want us to believe you?
The extraction, where was the extraction made?
Pennsylvania.
You were there?
And who made that extraction?
I believe it was Special Agent Tanzola.
And how did Special Agent Tanzola get that extraction to you?
You'd have to ask him. I believe it was using a Cellbrite product.
So what about is the USB not a physical box of the extraction, or is it all digital?
USB is just a storage device that the data would be placed onto.
So with the extraction and the USB, can you explain the process of the extraction being made and it getting to you and it getting put on a USB?
Normally in a forensic environment, the device is extracted, that extraction can then therefore be placed onto a different storage device for evidence storage or for sharing with other forensic investigators.
And so you said normally, but I'm asking you specifically to Bryan Kohberger's cell phone.
The data was placed on a storage device by S.A. Tanzola and provided to me.
Okay, and how did you get the storage device?
I believe it was brought back. I don't recall how I was given to it. It was still in the FBI packaging.
Do you have any personal knowledge of whether or not Special Agent Tanzola reviewed the data of the extraction before the search warrant in Idaho was obtained?
I don't recall.
Okay. Judge, this is when you don't have yet either. This is Defendant's Exhibit A to cell phone. And it does have a sticker on it.
Do you have an extra copy of that?
Pardon?
Do you have an extra copy of that?
No, one's, I handed two, right?
Yeah, and just in going forward, I need 2 copies.
I will. I heard that message yesterday, Judge, and I apologize. Moving forward, I will make sure that there's that extra. I'm assuming you went up for your clerk. So.
My staff attorney,
Yeah.
yes.
Oh, I got some right here.
And just for the record, as I've been doing, this has been marked Defendant's Exhibit Number A with a date on the sticker of 11/14/24. The document on which the sticker is placed, first page is affidavit for search warrant. Directed to the Moscow Police Department Forensic Lab.
Detective, how did you create the affidavit in support of the cell phone of the USB warrant?
How did I create it?
Yes.
Guess I'm not understanding. That's a vague question.
How did you go about drafting this? Is this a document that you had that you filled in from, or did you start from scratch? How did you
I don't remember the exact way that I did it, but it's not, this isn't very different from, say, an ICAC warrant that I would have had previous intentions to search the cyber tip information that would be already placed into evidence at the digital forensic lab.
So when there's knowledge about what you're asking for and lists of things to get, what are you basing that knowledge on?
I would be basing this on information that I've done in previous cases, other warrants that I have served, and other warrants that I have viewed from other investigators throughout my time.
Can you turn to page 24? You see that page?
Yes, ma'am.
And is that a page entitled Search Warrant?
Yes, ma'am.
Looking at the first paragraph of that search warrant, is there any reference to search warrant affidavit in the warrant?
No, ma'am.
And is the date of the crime on the search warrant?
No, ma'am.
On page 25, can you turn there?
What?
There's a directive to search the premises. Do you see that?
Yes, ma'am.
What's the premises located as, listed as?
155 South View in Moscow, Idaho, in the forensic lab. 155 South View, one word.
So you're gonna search the police building.
Does
right?
it say USB in that descriptor?
No, ma'am.
Can you turn to page 28? Who is Key Computer Forensic Lab?
Key is not a person, it's a thing. It unlocked the secure cubicle that the USB was placed into by myself so that it was secured. I had the key and entrance was obtained by Key in the Computer Forensic Lab.
That makes sense now. I thought it was the name of a company, and I don't know why, but that makes sense. Key Computer Forensic Lab. Who was ultimately in charge of searching the USB drive?
The data was extracted, or not extracted, but reviewed by several different people.
Okay, who are those people?
I don't know all of them. Myself looked at some of the information, but not all.
You don't know the
You
people?
said you don't remember all of them, but who else do you remember?
The information was also given to the FBI. The FBI had that information and they examined it.
And do you know who with the FBI?
No, I do not.
Unbelievable. Get the hell out of here. You don't know who you're working with? You don't know who's getting stuff? Who's running this fucking shit?
Can you turn to page 27? Can you look at page 6? Or not page 6, I'm sorry. Number 6, line number 6. Do you see that? What does that say?
A copy of the warrant inventory sheet were left with the drive.
And that does not indicate that a copy of the search warrant affidavit was left with the drive. Is that right?
No, ma'am.
Is that right?
Okay, I want to talk now about Amazon. Did you swear to several warrants for Amazon?
I did.
Do you know specifically how many?
I do not recall how many.
How were the warrants served? How did you serve Amazon warrants?
I believe that Special Agent Michael Douglas assisted in service of those.
What training do you have in Amazon accounts and records?
I do not have any training for Amazon specifically.
And I think you answered my next question, but there was a reference in the warrants to a special agent locating an Amazon account. Is that the special agent Douglas?
I don't recall who was that, who found that information.
How was an Amazon account located?
I don't know.
How? What?
In your affidavit, where you've got language that talks about what Amazon holds and how it identifies and the list of items that can be collected, if you don't have any training in doing an Amazon warrant, how did you know that? To put that?
I was relying on the experts that have worked with or served in warrants to Amazon previously. I believe that information came from Special Agent Michael Douglas.
And in your affidavit, did you indicate that that was based on your knowledge or on someone else's knowledge?
I based it on mine because I spoke to Special Agent Michael Douglas about it, and he was the one that informed me that this was the information that we could request.
And so did he provide you with a kind of a mock-up affidavit to use so that you would know what language to include?
I don't remember if he gave me a mock-up, but obviously he would have helped me with the wording of it.
The wording of the warrants is pretty technical, right? All the list of items that is asked for.
Any electronic service provider usually has their special way of asking for things.
And so since you don't have training in Amazon, you relied on Special Agent Douglas for that?
Yes, ma'am.
Okay, Google is the next one I want to talk to you about. What's your training about Google?
Again, I have no specific training to Google. I've served various email or warrants on Google for other means.
Is your experience with Google isolated to this case?
No.
You've done Google warrants before?
Oh, yes.
How did you get the form that you used for the Google warrant in this case?
The Google form, I probably relied on previous warrants that I've served.
Do you know how many warrants you obtained for Google in this case?
It's 3.
On January 3rd, that January 3rd, 2023, that warrant asked for Bryan Christopher 1994 at Gmail, 2 phone numbers, and an IMEI number. What's an IMEI?
International Mobile Equipment Identifier.
And how did you get that number to put in the January 3rd, 2023 Google warrant?
I do not recall.
Yeah, you do. Don't you lie. I do not recall. Well, I mean, but this is so awesome.
Okay.
This is so awesome. This is all lies.
Were you, in preparation for creating these warrants, were you having communications with Google?
Specifically about these warrants?
About being able to get the data via warrants?
I don't recall communicating with them specific to these warrants.
Okay, I'm going to hand you what's Defendant's Exhibit F to the Google Memorandum in Support.
Here she goes.
You recognize that?
Appears to be an email between myself and a Francis from Google.
So is this how you were communicating with Google via email?
I was communicating with Google for other, I'm not sure if this is the one for this specific warrant, I guess is where I'm getting at. There was question of what Google could provide. We served Google at one point with a warrant. They said it was, they couldn't do it because there'd be too much data. So they were trying to assist us in, well, basically not spending $100,000 of getting them data.
So to be clear, when I'm talking about the communications generally, I'm talking about your communications with Google about all the warrants. So was there email and telephone communications or just email?
I believe I spoke with their legal representation on the phone. I don't remember if there was other conversations.
Do you understand the difference between a personal account and a not personal account on Google?
I do not.
Well, there's reference to DeSales and DeSales helping from their end. Can you explain that?
I don't recall what that means.
Do you recognize what DeSales is in the course of this case?
It references an email address that was associated with the defendant.
Okay, and that email address associated with the defendant is a college that he attended, right?
Yes.
And so what was there communication with DeSales about them not wanting to produce records pursuant to a warrant because it was educational records protected by federal law?
I was part of a little bit of that. Officer Detective Payne knew more about that conversation, but yes.
Now he can be recalled.
And so what I'm trying to understand is what was DeSales doing to help?
I believe DeSales was just waiting for a warrant. I don't recall completely.
And did you serve the Google warrants?
I believe I did.
I believe you said you did?
Yes.
And consistent with what you've said earlier, you did not include an affidavit in support of search warrant with that? Why did you choose the timeframe of January 1st, 2021 to December 30th, 2022?
I don't recall the specific reason why we went back to January 1. It was to include the time that we believed that the defendant had entered Washington to become a student nearby the crime scene and just prior to that.
But you know that he didn't come to Pullman, Washington until June of 2022, right?
Correct.
Did you review the Google warrant return emails?
Yes.
Did you review? So you said you reviewed them. Are you the one who's in charge of evaluating those materials for this case, or is that designated to somebody else?
The materials came to myself, at which time it was disseminated to other investigators and the FBI as well.
Is it fair to say that between warrant 1 and warrant 3, it's gone from 2 gigs to over 13 gigs of material?
It was substantial information.
And have you done anything to verify whether or not the materials produced are within the scope of the warrants?
I usually made sure that they were from that specific account when it's received, but I did not go into depth of the evaluation.
let's talk, the final area is about the Apple warrant. What was your role in those warrants? In that warrant, sorry, not plural, singular.
I don't remember that specific one. I know I was involved in a lot of the Apple iCloud warrants.
What kind of communications did you have with Apple to facilitate getting the warrant?
I don't recall prior to.
I'll hand you what's been marked as Defense Exhibit C to the Apple warrant. It does have a sticker on it. And it's not to the Apple warrant, it's to the memorandum in support.
Exhibit C attached to their memorandum dated, exhibit sticker dated 11/14/24. Appears to be a printout of some emails.
Man, if I was Steve, I'd be one pissed man.
Have you reviewed those?
Yes, ma'am.
Can you, does that help refresh your recollection regarding what communications were occurring?
It appears that there was communication between Apple and FBI.
Okay. And were you included in that?
I believe I was.
Okay. And did that include chats?
I believe the word chat means to chat, to talk.
Like telephone talk or Zoom talk, or what was the method?
I believe it was telephonic.
So what kind of help were you getting from Apple, and what was the FBI getting from Apple?
I don't recall the conversation. This was more specific to the FBI's current investigation. As I stated in my email there for the stalking investigation, I was merely just privy to their conversation.
Have all of their materials related to that been turned over?
Who's there in that sentence? Kelsey?
Pardon?
Who's there in that sentence?
Sorry, FBI.
I do not know. I wasn't, yeah, I don't know.
I have no further questions.
Few questions, Ryan.
Ashley Jennings for a few.
Okay.
He said no. Can I stand here? No.
Just a few follow-up questions. When you received the evidence back from these various providers, did you have access to what we refer to as affidavit for search warrant and Exhibit A?
Yes.
Okay. And did you use that to determine the scope of what you would be searching for from those providers?
If I was to be doing the investigation, yes, I would have looked at those items.
And you testified that several investigators helped MPD in review of evidence back from providers.
Yes.
To your knowledge, did those investigators have access to the affidavit and the Exhibit A?
Yes.
I don't have anything further. Thank you.
Ask him how. How does he know that?
No, Your Honor.
Oh, come on.
Thank you, Your Honor.
I have no further witnesses.
All right, why don't we take a 10-minute recess and we'll then pick up.
Okay, guys, we are on a 10-minute break recess here. I don't know. I think all the I don't knows. I don't know how we did this. I don't know this. I don't know that. I don't know. I don't know. I don't recall. I don't know. I, you know, I, oof, yeah. Basically, what these two gentlemen just testified to, and I believe that they're going to talk about in their argument as to why they should be suppressed. First of all, where's the chain of custody? People are filling stuff out. It's incorrect. There's case law supporting all of this stuff, that this stuff gets thrown out. I don't. I mean, Your Honor, we need to be asking clearly other people questions because these people don't know anything. So if we want to have a motion to suppress, if we want to have a hearing to suppress, we're trying to ask them information so we can show things so that you're getting reliable information so that you can then make a informed decision. I mean, how could you make an informed decision? Like, what did you learn here today? What I have learned here today is that these people that were on the stand weren't clearly running an investigation because they don't know how anything was done. They have no training and experience. All of their reports, they said it's group effort. Group. But then if it's a group effort, then they'd be on the hook for knowing these things. They don't know anything. They don't know why they put certain dates down. They don't know why how did you even know that this existed? How did you know that one of the accounts for Bryan Kohberger existed? Oh wait, but it was that wasn't even an account of his because you didn't add the 1984 at the end. I mean, this is absurd. It's because they didn't do any of it. It's because the IGG did it all and the FBI withheld all of that, ran their own investigation. Then at some point said, okay, here's the name, Bryan Kohberger, go ahead. Now you know, because you're not going to give us jurisdiction, it's your jurisdiction. Here you go. I don't know how are these now? How are these officers going to testify during a trial? You understand that all of these jurors are going to hear, I don't know. They can't just change their testimony and all of a sudden have these answers to what they did. And when you're questioning people and they don't know why they did something, it's just like, and the actual answer is that they do know. They do know where they got it all from. They got it all from the FBI. Mowry just testified that Nick Balance was literally sitting right next to him in a room by him and himself. It was just those two dudes in a room together when he was on location. Unreal. I'm still laughing over the fact that they brought a bear cat in the driveway of Bryan Kohberger's parents' house. Like, honk, honk, here we are. Here to come, you know. It just pulled right in. They had drone footage. They were like running in Afghanistan, like going in and getting like, do you understand? Like, what do you mean you don't have, what's his name? Whoever did the drone. How do you not have, that would have been recorded. Where is that? Where is any of this shit? How did you develop probable cause to get these search warrants if you didn't? If this doesn't prove to everybody that IGG was 100% used and you relied upon it and then you just wrote up all this crap, you didn't even know I mean, this is bad. I was expecting to get some answers. This is way worse than I expected. I was expecting, like, okay, we're going to get some answers here. So I think your legal argument is, Your Honor, they don't even know why they went and got these warrants. So if they don't even know how they obtained these warrants and what came back, and they're lying about communicating, this guy, Maury, says, I never communicate with Google. He's just handed a friggin' Google chat where he did communicate with Google. I mean, I don't even know what to say. This is unbelievable. Like, absolutely. I mean, I think they said, I don't know, and I don't recall more times than Melissa Jade and Vanessa Walsh ever did. And I just know when you're trying to question somebody that's just going to keep on saying, I don't know, I don't recall, then you're going to have to go get all of these pieces of paper to like show this, or this. Because if you just sit up there and say, I don't know, and I don't recall, I don't know. I don't recall. I don't remember. That's a big one. I don't remember. How do you not remember the biggest case of your life? How do you not remember the biggest case of your life? Why didn't we ask a question of what were you guys doing up until you got the name Bryan Kohberger from the feds? What were you doing, Maury? I don't know. I don't remember. Think about that. Brian's name, according to Moscow, they didn't get that until December 19th or 23rd or whatever day you want to go with, depending on the day that Payne testified, because he testified to something different last time. So what were you guys doing up until then? On all these things called affidavits, they were putting based on my training and experience. And they got no training and they got no experience based on their answers today. So based on my training and experience. And then she asked Maury, well, didn't you say that it was based on your knowledge of whatever? And she's like, well, wouldn't that be actually based on so-and-so's knowledge? Well, no, because he told me, so then it became my knowledge. Excuse, what? No, you were just repeating his knowledge because you didn't know it. You were repeating what you were told. That's just like a Google search. That's like a Richard Allen in the middle of a court proceeding for trial for 130 years that an expert witness went out on the break and Google searched and asked Siri, why would an iPhone 6 have water damage? Is that your knowledge now? Okay. I think it's crazy that Payne was a cop for 2 years in Moscow before this murder happened, and he never typed up an AT&T warrant before. I think that's crazy. What are they doing over there? No, I think she was referring to August 2023. That he asked for something. And it's like, how would he know that? It's just, there's no probable cause here, guys. That's just that's the bottom line. And it's truly unfortunate because if Brian's, the killer and stuff gets thrown out because they picked money. They picked enrollment. We have to have an arrest before these kids come back to school because no one's going to send their kid back here and it's going to affect our enrollment. There was a reason. I mean, absurd, just absolutely absurd. So that's what I mean when I say that they picked money over, they picked their university. They picked the money over doing this the right way. you know, but you don't get to violate our rights. And if this case, if you can do what was allowed in this case, this is precedent. And it sucks because, you know, if he truly is the person that did it, you know, you think I want something like that running around? No. But you can't violate, because then people that are in it, we don't even know, because now it's the integrity of everything. You want to tell me now that you don't think that knife sheath's planted after everything that we've heard and seen? That's the only thing that you have against this guy. And what it looks like to me is that everything that you would have went for should have like returned and had fruits, and it doesn't. And so all you have is that sheath, and it miraculously is there after 911 isn't called for 9 hours. And I'm not saying that the law enforcement officers planted it. I'm saying somebody, that could be another person, like a citizen, like somebody that wants to blame it on that person. How you think that 3 unknown samples or DNA, 2 of them are blood, male blood is there in that house on that banister, at least one. Then there's blood on a glove. And you don't think that that's relevant? And Hitler says, well, it just looks like Bryan has accomplices. I was like, oh my God. We're not talking about that. We're talking about the process here. We're not to the case yet. We're not arguing the case yet. We're talking about the process. That's what we're talking about here. That's what a suppression hearing is for, is the process. I think based on the answers, Hitler has no choice but to do some certain things. Okay, based on their answers, like they did not do any favors for themselves today at all. Payne says not necessarily, that they did not rely on the returns from search warrant 1 of AT&T to get search warrant 2 of AT&T. Well, then why didn't you just go for the pen, trap, and trace? What did you need from going and getting the 12, like November 12th to November 14th? What did that serve a purpose for? Because those returns that you got back, what did you use for that? And you guys, there's certain questions that you don't even have to ask these idiots, okay? Once they're already giving you certain answers. I mean, this is embarrassing. And their answers will lend you to believe that everything that they did was unlawful. Like, it was just bullshit. I don't understand why no one's just saying, hey, yeah, the FBI was just telling us to write down. I would have just said, why isn't the FBI writing up these search warrants? Why are you? Well, because it's our case. Well, clearly you guys don't know what you're doing. Why didn't you just give it to them? Right? You guys get where this is going? Like, why are you guys running this investigation? Why do you guys even have this investigation? You don't know what you're doing. So then why wouldn't you give it into the hands of somebody that does? Doesn't that make sense? Isn't that what normally happens? I could never imagine getting on the stand and somebody asking me, I served a search warrant. Why did you serve a search warrant? I don't know. What does this mean when do you know what that is? No. No, I don't. Were you involved? I think I was involved. I don't know. I can't remember. You don't remember serving a search warrant to, AT&T to get Bryan? Like, when it's just like, this is just like, I can't imagine. Like, no, I don't recall that. Oh, I don't know. I would have been like, well, can you tell us what you do know? Just sad, sad, sad. Oh yeah, we're definitely gonna be sending some flowers. We need to send some flowers to Moscow Police Department. I mean, geez, it's like gonna be a funeral over there for the next week. Can somebody cut and clip every I don't know, I don't recall? You know, do we think that, I think they're all lying. Do you think that the judge is seeing that? William says, Lana, they are all caught lying and the judge sees it. Well, I mean, right? I just have to either say one of two things. Either I believe you guys and you guys don't know anything, or I don't believe you guys when you're saying I don't know. So either way, based upon what happened here today, I have no choice but to grant a Frank's hearing. You know, I don't know. Is that better on the sound? H-Bag thinks that the judge sees it. Now Moscow's gotten me saying I don't know because of their I don't knows. Absolutely, what a circus. You were the lead investigator on the Moscow, Idaho murders. Yes, I was. I was the lead. I told everybody what to do, where to go. I told everybody, you know, I synthesized the information and I, you know, where was it at right here? When Payne says, oh yeah, Payne, yes, I was the lead. I directed the teams. I synthesized the info. And, you know, it was a group effort with this affidavit. It was, you know, the info was brought to us, you know, by balance with the cell phones, you know, brought it to the team. Like, you know, it's all I can ever just talk about. And then he's like, you know, this was just a running document. It was a living document. Exhibit A is a living document. It was a group effort, man. I don't know how many search warrants. Several. Best was when Elisa says, have you ever obtained a AT&T search warrant before in your life? No. Never. This is the first one I've ever done. Just like, wow. Okay. They served the first AT&T search warrant at 10:03 a.m. They got it back at 3:30 p.m. And then he was asked, well, what happened? What did you guys do between 3:30 p.m. and 4:53 p.m.? I don't know. I don't know what happened. Well, what do you mean? Like, what did you get? Like, what information did you obtain between 3:30 and 4:53? Because that's when you obtained the second one. And his answer was, she said, well, was it required to get AT&T warrant 1 for AT&T warrant 2? And he said, no, not necessarily. And then it's like, well, how are you saying no, not necessarily? So then you know what you were doing between 3:30 to 4:53? They gotta get a little bit more combative with these assholes. When it said like, how long did it take you to draft your trap, trend, and trace, affidavit? And he said he doesn't know. I don't know how much time it took me to do that. So what did you do between 3:30 and 4:53 p.m.? I don't know. I don't know what happened. Balance did whatever they do. Okay. So how could you submit an affidavit at 4:53 p.m. and get something returned at 4:53 p.m.? You obtained something at 4:53 p.m.? Looking in Bryan's phone before warrants are signed. What do you think about that? You clearly have proof of that. How did you know about the DeSales email? I don't remember. How were you aware that there was an Apple product? Oh, because when we seized there was a receipt in his car that talked about an iPad, and the car that was in the garage. How come you put the wrong email down for an email that you were searching for to get these returns? So if you put the wrong email down, then it couldn't have possibly given you anything. There we go.
All right, we are back on the record in State v. Kohberger. Defendant is present. Counsel are all present. I'm heard that there are no more witnesses to present by either party. Is that accurate?
Yes.
Yes, Your Honor.
All right, we'll move to argument then. The defense may proceed.
Judge, I'm going to cover several of the warrants, and then Mr. Logson's going to cover 4. So I'll just wrap all of my argument up instead of getting up and down for each one. My oral argument is not meant to rehash every point briefed or every argument briefed. I'm giving you big picture comments based on the testimony, but I want to make it clear that we're not waiving any written arguments. While I question Corporal Payne and Detective Mowry about some exhibits, but not all, it was not an indication that others are not important. I wanted to make important points, but not belabor. With IGG and Franks having been addressed yesterday, and the fact that the primary issues that I'm addressing have to do with general warrants, I'm not going to rehash those arguments, and I'm going to focus on the legal issues, beginning with the AT&T Warrant 1, Pen, Trap, and Trace, also known as AT&T 2, and the cell phone /USB drive. The Fourth Amendment requires particularity sufficient to prevent the exercise of discretion by an executing officer. The particularity requirement's objective is that necessary searches should be as limited as possible. A search warrant must be particular enough so that as to what is taken, nothing is left to the discretion of the officer executing the warrant. The government cannot seize the haystack to look for a needle. And there is an undisputed privacy interest in cell phone data, including cellular site data pursuant to Carpenter. All 3 of these warrants were issued in December 23rd and early January 2023. The 2 AT&T warrants were issued on December 23rd, 2022, within an hour of each other. The first did have a temporal narrowing. AT&T 1 had November 12th, 12 a.m. to November 14th, 12 a.m. The warrant itself was extremely broad and did not incorporate the affidavit. In support of this actual failure to incorporate, the officers admitted that they did not incorporate in the search, but to the extent that the state is going to argue that when the warrant says upon offer and proof, that is the same as hereby incorporates an affidavit, I pointed out the language in certain search warrant affidavits to show you that they do know what it means to actually use the language herein is incorporated Exhibit A. And that same language is not used in a single search warrant affidavit. So the incorporation that would be a remedy for this issue potentially of particularity doesn't exist when the search warrant affidavit is not included. Even if for some reason you were to determine that there was English language meaning upon proof and oath is the same as hereby incorporated, the language in the search warrant affidavits themselves is extremely broad. The affidavit of return signed by Detective Paynes, this is on affidavit AT&T 1, says that the warrant was served by email, and as he indicated, it did not include the search warrant in support. The description of the property in Exhibit A to AT&T described the property as just a phone number with no other description of the property, which indicates a lack of knowledge of what was actually seized and going to be searched. The second AT&T warrant and install pin trace was requested within 1 hour of the first warrant return at 3:50. The data from warrant 1 was analyzed such that by Special Agent Balance, such that Detective Payne was relying on Balance in his affidavit to support it by saying that the data that had been in their hands for less than an hour supported that the phone was possibly off going south on Pullman at 2:42 a.m. And there is just got to be a question for everybody of how does this massive amount of data get analyzed in an hour to create a second broader warrant? The warrant language in AT&T 2 pin trap trace is extremely broad, and the time frame goes from June 23 to 2020, June 23rd, 2022 to present. The crime of homicide was stated, but the date of the crime was not stated. There was no other specificity in the actual warrant. The warrant asked for extensive data, location data, timing reports, cell tower information, and installation of a pin, trap, and trace, among other many things. And when the warrant was served, a check the box form was included as a cover sheet to AT&T. Turning to the cell phone is first seized when Bryan is arrested. It's copied by Special Agent Tanzola without a warrant, and then that USB drive makes its way to Idaho in an unclear fashion. It sounds to me like it came back with Corporal Payne, who was there for the arrest. And when that warrant is obtained for that USB drive, it's put in a safe with just a copy of the warrant that has no date of the crime, and there's nothing particularized about what is to be searched. This creates a general warrant with 100% total discretion and nothing to limit the search. And if you believe that access within a database by somebody unidentified other than Mowry, who's going to evaluate that warrant, that they're going to look and pull that finalized search warrant from the database that everybody supposedly has access to, looking at that search warrant affidavit, there's full discretion to search the USB drive, there's no limitations and no efforts taken to address that. Turning now to Google and Apple. A very instructive case on Google and Apple is the Idaho pilling case, which is 721 F Sup 3D 1113 2024. It's almost totally on point with this case. It is a federal case out of the District of Idaho, but it really couldn't be more instructive in terms of looking at these issues with Google and Apple. There's without a doubt a recognized protected interest of private information in Google and Apple records. Google contained private emails, schoolwork, research among things, and Apple was essentially a copy of a phone and iPad that went all the way back to 2016. 2018 was an indication of when an iPad was purchased, but 2016, according to the documents that were prepared, were when it was identified that an Apple account was first created. Carpenter applies, and to the extent that there may be third-party materials like search history not related or documented, nothing was done to do any sort of segregation with regard to Apple or Google. For the Google warrant, by January 3rd, 2023, law enforcement knew many details that they could have used to narrow those warrants. They knew that Bryan hadn't been in Pullman until June of 2022. They knew the names of the deceased, which were not included as language in the Google warrant. They knew the fraternities and sororities. They knew the students' names who had also been at the house on the morning of November 13th, 2022. They knew the date of the crime, of course. They knew emails. They knew social media accounts and names. They knew where students worked. They knew their friends. They knew their phone numbers. None of that was included in the Google warrant to help limit and make that something other than a general warrant. There's no language incorporating these search warrant affidavits, making these broad, sweeping categories, making the productions bigger and bigger. In Google, it went from 2 gigabytes to 13 gigabytes by the third production. And it appears that it's really unclear to these detectives that have taken a huge role in this case, who's evaluating what data and to what extent and what is being produced by it and what is within the scope of what is in an already broad warrant. For Apple, we are missing some sort of legal process that the state just hasn't filled the gap on, and these witnesses don't fill the gap on. We don't know what the legal process is that is referenced between the first request for a preservation in December 21st, all the way until August, when there is a production on a warrant. The steps that have been taken in between to get the information to put into the warrant are completely unclear, and to the extent that these officers who swore to the contents of affidavits now have no memory of what that is, that's invalidating of those warrants.
Yes, it is.
As for the arrest and the car and the apartment, what I will close by saying on those, because it's not an issue of general warrant or a discussion of particularity, those are more reliant on the issues associated with IGG and Franks. And with that, I'd ask that you find that the warrants that I've just discussed are general warrants, not particular warrants, and they should be suppressed.
Do you want to respond to that, or do you want to have the defense argue the additional warrant issues and then address them all?
I'll take your lead, but I'm happy to just to piecemeal this, and I can address just those. I can make this pretty simple for the court. We don't have to go down the rabbit trail that the defendant would like you to go down. The search warrants regarding the particularity requirement. And this group that we're talking about is Apple, AT&T, there was a first and a second, Kohberger's phone, and then Google. All of these warrants were not general warrants. They were all sufficiently particular. They were specific to the type, each one of them listed that they were specific to the type of crime, the location, and all but one of them had temporal limitations. And for the one that didn't, that would be the cell phone warrant. That warrant was more particularized in the types of data that officers were allowed to search for. It's the state's positions, these were not general warrants, and your court can determine that just by looking at the face of the warrant. If you have any questions, otherwise, state submits, you should deny their motions to suppress for these issues.
Well done, Ashley. Just stellar. Stellar. Oh, come on, Jay, baby.
Your Honor, I was asked to argue the motion regarding the raid on my client's parents' home, the search of his person here in Idaho, as well as in Pennsylvania, as well as and the Amazon warrant. I think for the most part, I'll just rely on the briefing. I just want to clear up a couple of things. One of the areas that was covered in the Pennsylvania home raid was that the state had to have a valid warrant in order to enter the home. I think in the briefing, it gets a little confusing, but the point was not that Mr. Kohberger couldn't have been arrested as he was walking down the street via the usual channels in which that could have occurred. The point was that they had to have a valid warrant in order to get into the home. The only warrant that they have is the one that we're challenging and via the Franks motion. And so that was the purpose of that argument. The other issue in terms of choice of law, it sounds like the state's kind of accepting that Idaho Constitution should apply. We set out a few different reasons why that should be the case. It doesn't seem like there's a big argument going on there. So unless the court has questions about it, I'll leave that alone. And then the other issue that I wanted to touch on is the right of privacy in the information that we have in our Amazon goings about why should the state have to have a warrant for that. I thought we set it out pretty well in the briefing, but I think, the big concept and takeaway here is in Carpenter and Riley, the United States Supreme Court starts doing something different. And I think what the court is starting to recognize is that to a great extent, the United States has become a sort of panopticon. That is, the concept of the panopticon is you have a prison in which you only need a small number of guards because you have a very heavy-duty surveillance system. In the United States, we have via our phones, via the internet, much of what we do is now surveilled and very easily accessible. And so the fact that we have the third-party doctrine made sense when it was being adopted back in the 70s and the 60s. It stops making sense once all of this information is easily accessible in the way that it is. And so our point is that the judiciary has to have a role in this. There has to be a judge between us and the executive. Otherwise, we're essentially allowing the executive to know everything about us all the time. And so the state makes the point that similar to the one that Professor Kerr made about going
in Miller going and getting bank materials, once those were things that could be done simply and efficiently via these records, a person didn't have to go out and get the cash. The state argues in this case, because of Amazon, Mr. Kohberger didn't have to go someplace to purchase items. All of that would have been out in public. He's doing it on his computer. And so why should that make it private? And the reason why that has to become private, Your Honor, is because of the vast amount of information that is now so easily accessible to the government. If we don't require a warrant, we essentially put all of ourselves at hazard of being snooped on at any time. And so I also just want to just briefly bring up, I think yesterday the court had talked about privacy rights with the IgG databases. And I certainly want to make sure that we are preserving that argument. We included it in the briefing. We do believe that Americans have a privacy interest in the genetics they share with other people, and that other people then place within these databases. So that is not something that we intended to abandon in any way yesterday. If the court has no other questions for me, I would rely on the briefing.
Thank you.
Thank you.
Your Honor, I'd like to address just the third-party doctrine, and then I'd like to turn it over to Mr. Thompson to address the other motions to suppress. And the case that we're talking about is the Amazon records, and that's what has to do with the third-party doctrine. And the U.S. Supreme Court case State v. Miller is the controlling case here. And Idaho courts, as explored in my briefing, apply Miller. And there's no reason for this court to diverge from that Fourth Amendment analysis. The documents are Amazon's business records. They detail transaction history. Business records are most akin to bank records, which is allowed. Applying the court's reasoning from Miller, again, these documents are business records of Amazon. They're not the defendant's private papers. Amazon is a party to those transactions. They have a substantial stake in these records. And the defendant took the risk when he revealed his affairs that this information would be conveyed by Amazon to third parties, including the government. It's the state's position, and it should be the position of this court. The defendant does not have a Fourth Amendment privacy interest in Amazon's business records. Thank you, Your Honor.
Good morning, Judge. I'm going to address, I guess, the remaining warrants or the questions raised by the defense about the remaining warrants. I'd like to start first with the warrants for the residents in Pennsylvania. That expands into Mr. Kohberger's person under the Pennsylvania search warrants for his person, for his car, which was in Pennsylvania, and then the defense also raises questions about statements made by Mr. Kohberger to law enforcement. First, as to 119 Lambston itself, one of the first things the defendant offers to the court is claims that there was no local warrant, valid local warrant, and that simply isn't true. As the record clearly demonstrates, there were 3 valid local warrants, Pennsylvania warrants, for the residents, for the defendant's person, and for his car. The defendant then asserts, and I appreciate Mr. Logston's clarifications, but essentially the defendant asserts that there needs to be a separate special warrant in order for Pennsylvania to take the defendant into custody as a fugitive from Idaho on our charges. And as we cited in our briefing on this, the statutes in Pennsylvania and Idaho are virtually the same, and they clearly contemplate that a felony fugitive can be taken into custody without a fugitive warrant under the circumstances that exist in this particular case. Now, if the issue is the law enforcement presence or access to the defendant inside his parents' residence, we would submit that's already addressed because the Pennsylvania State Police had a valid search warrant for the premises, for the defendant's person, and for his car. So they had lawful process to be where they were, where they found the defendant and took him into custody as a fugitive. The knock and announce, there was discussion earlier today and the explanation of what happened with the dynamics of the knock and announce. That's detailed in Sergeant Lang's statement, which is now has a current cover affidavit to it filed with the court. That's S5. I'm not going to publicly go through all the factors unless the court wishes me to, because they are quite incriminating as far as the applicable factors that would justify either an abbreviated knock and announce or frankly elimination of knock and announce entirely. And from what we have before the court now, it's clear that Pennsylvania's police were operating in a dynamic sense, reacting to real-time information that was coming in. That's all documented in the various reports and log sheets that have been submitted with our pleadings, which are not particularly lengthy in nature. Finally, as to the defendant's statements, I think the key notion here on any statements the defendant made, and frankly, he really didn't make much in the way of incriminating statements, is there was never any interrogation. He was Mirandized eventually, but even the prior conversations that occurred with Pennsylvania law enforcement, there was never interrogation. And so Miranda is not implicated, and so there's no issue on the statements themselves. As to his car and his person, as I've already mentioned, there were valid specific Pennsylvania search warrants for each of those. So those are presumed to be lawful. There's been no substantive attack on those. There is a motion to suppress regarding, and I'll use the air quotes, arrest warrant. And frankly, I have yet to be able to figure out what arrest warrant is being referred to. But again, all the actions in Pennsylvania were taken pursuant to valid warrants, search warrants from the Pennsylvania courts, arrest statutes. And so we don't see that there's any issue before the court there. The defense also raised the issue of a search warrant for the defendant's person in a separate motion, which appears to be the search warrant for the defendant's person here in Idaho when he was returned to Idaho. And as the search warrant and the affidavit for the search warrant show, which were attached to our reply, there was a valid search warrant for that. I think any issues to be argued beyond that relate to the IGG and Franks that are already pending with the court. As far as the defendant's, the search of the defendant's apartment in Washington, for whatever reason, the defendant did not include all the documentation with their particular motion to suppress, but we provided that in our response, that there was the Washington search warrant. There was also an amendment to the Washington search warrant. The Washington search warrants, the applications, included all the information, the Exhibit A information from the state, and then the WSU Police Department added their additional state of Washington specific information. There's nothing that questions the validity of that warrant on its face. So, Your Honor, unless the court has questions, I don't have anything further to offer in the way of argument, oral argument.
Thank you.
Thank you, sir.
Foxton, any rebuttal?
I think I just rely again on the briefing for the most part. In terms of the knock and announce, I think the totality of the circumstances of this particular raid are something that the court has to be cognizant of. If Dylan Roof could essentially be picked up in a parking lot outside of a drugstore or whatever it is that they were able to
Telling
do.
me facts about which I have no idea, and so it's not going to be helpful to compare it to
Well,
whoever Mr. Roof is. So
I guess the point is that in this particular case, the state manufactured the exigencies if they had them at all. The reality is, as they explained in their own affidavit, they're essentially watching Mr. Kohberger as he moves around his house via snipers. I mean, they were quite safe, and there was simply no reason to bash the doors in momentarily after yelling from their Bearcat.
there's two issues. There's officer safety. There's also destruction of evidence concerns.
In the cases that we cited, Judge, when The claim has been that there's evidence being destroyed. The evidence, what's known to the officers is something along the lines of, they hear somebody running away after they announce themselves. It's not typical that the police simply don't knock and announce at all in those cases. They usually give the person the opportunity to surrender, but it's not a particularly long one. And in this case, they don't do that at all. And the only thing they knew is that he's walking around from room to room and that he has some kitchen gloves on. And I don't think that equates necessarily to the destruction of,
Well, that's not all they knew, but I won't go into the detail in order to preserve so as that we don't go into those issues.
Thank you, Judge. But beyond that, we'll rely on the briefing. Thank you.
Okay. I'll take the motions to suppress under advisement and issue ruling forthwith. The next issue is the state's motion to compel regarding the defendant's expert disclosures.
I'm sorry, Your Honor, the defendant's motion to compel the
Did I say the state's motion to compel? The defendant's motion to compel regarding the state's expert's disclosures.
We did file ours yesterday, so their motion may be coming.
Well, I would be impressed if they had filed something already on that, given they were just served yesterday afternoon, so.
They were, thank you. Your Honor, we are here on our motion to compel, asking that the court remedy what the state has done with their expert
He is such a smart
disclosures.
ass.
We rely on Idaho Criminal Rule 16 and the court's order setting out what we should do and when we should do it in this case.
Let me ask a question from a framework standpoint. I don't know what these folks are going to testify to at trial, specifically as it relates to what they've disclosed. The way expert disclosure issues usually works, I don't tell a party what you have to specifically disclose about your experts. You disclose about what you think you need to disclose. If you haven't disclosed it consistent with the rule and you try to offer it, there's a good chance it may not come into evidence. That's the general framework, so I'm a little, I guess, concerned about what appears to be you asking me to tell them what to say in their disclosures.
The court brings up a really, really good point. And I think it's a remedy the court has and one that we would hope and ask the court to issue in this case. I think when we filed the motion, Your Honor, we had a couple of disclosures that could appear to be disclosures with wiggle words in them.
Yeah, wiggle words are not going to save the lack of disclosure. I'll let the state know that right now. The fact that you say, well, he could talk about anything else, doesn't mean he's going to get to talk about anything else.
In an abundance of caution, we were worried about those words. I appreciate what the court's saying, and I'm going to make this really short. The lists are problematic for us. There are 4 or 5 experts with lists. I understand what the court said. I like what the
They
court
also
said.
have reports that they reference.
The lab people do have reports. I understand those are their opinions. When we're talking about, and I'm going to specifically talk to you about their disclosure number 7, it's an FBI agent, Douglas. There's a list of financial records that he collected and looked at. Other than that those records exist, there's not a report telling me what they mean to him at all. If he's limited to say, I collected these records, this is what we have.
My understanding, the state can correct me, is what I understand from the briefing is respect to that. And I think that's the Amazon documents, correct?
Those were some of those documents, Your Honor. There are a lot of others.
Was his expertise was in extracting or reviewing the information and how those were sort of obtained electronically and then simply guiding through, well, this is a transaction on this date that does this, which is not necessarily expert testimony, it's simply testimony.
No, but I believe it's a different expert that they have to do that does not have a report.
But is that expert testimony?
that, let's just say, Mr. Kohberger on X date purchased a television, if for some reason that were to be important, and that this transaction demonstrates that this is Mr. Kohberger's account, this is Mr. Kohberger's credit card, and this is the purchase on Amazon. And that was delivered to this address associated with Mr. Kohberger.
Those are factual issues, Your Honor. It's when we get to what do they mean, or I put these things together and I've made this picture out of something. That when we get to opinion, I appreciate what the court's saying. It sounds to me like lists don't do it if you want to interpret a record. That's what we hope to hear. That's what I wanted to accomplish today.
Well, I think it's pretty clear. You cannot simply say an expert's going to talk about topic A, topic B, topic C, and then be able to give a host of opinions that fall within those topics. The requirement is to list what their opinions are and what they relied on to give those opinions. It's different than the civil rule. I don't think they have to give as much detail as the civil rule requires, but they have to at least give what the opinions are, and I believe what they reviewed, as I recall the rule off the top of my head.
I believe the court's about right. There may be another term or two in the rule that's specific, but I hear the court loud and clear. I'll point out one last thing and stop, because I think I understand how the court interprets these issues and these rules. When you look at page 9 of the state's objection to our motion, and in the second to last paragraph, they tell you that they will continue to supplement their expert responses based on later discovery or whatever they decide to use. That whatever they decide to use has me worried. So I wanted to bring that up. I appreciate the court saying the court's going to apply the court rules and the discovery rules and follow the case law, and that's all we want. Thank you.
And so that I'm clear, as the state's approaching to talk about this, in terms of supplementation, it's allowed. It needs to be seasonable, which means it has to be not just whole cloth new experts, for example, without good cause showing me why that's necessary. It needs to be seasonable in the sense of the timing of it based upon when the information was received, when it was determined it was necessary to supplement. And then obviously we'll look at that in relation to what may prejudice the other side in terms of the timing of it.
Certainly, I understand that. Their discovery deadline has come and gone. If something brand new happens, that would be a different issue. I would assume we would deal with that then. It's when I read whatever we decide to use, that's very, very broad. That's it. Thank you.
I can keep this pretty short. I don't think that there's really much in dispute at this point. State's position, we've complied through our expert disclosures with Criminal Rule 16b7, as well as your court's scheduling order. State understands the framework that you've outlined. We were under the same impression, and I don't think that there's anything else in dispute.
Yeah, so let me give you a word of caution. Sometimes there's dissonance between what an expert thinks that they're going to talk about and what the lawyer understands from that expert. And the lawyer submits these disclosures. And I think it's really important that you be on the same page if you don't have a specific written report from the expert about what it is they're going to talk about, and make sure that you have supplemented and that you have provided a listing of the opinions that are going to be provided and whatever else is required under the rule in terms of what that's based on. And I would encourage both sides to over disclose those opinions in caution rather than under disclose. Because two things. One,
you may find yourself in a bad position if you're not allowed to go into an opinion you felt you were going to be allowed to go to because it's not disclosed. And two, I don't want to spend half our day at trial with me saying, where's that disclosed at? And then chasing the jury out while you dig through your thousands of pages trying to find where that is. And so the more exhaustive your disclosures, the less likely it is it's going to draw that objection, and the less time that we're going to waste at trial trying to find where you disclose that. And so I think sometimes, and I'm not saying you did that in this case, I think sometimes lawyers view this expert disclosure requirement as sort of tedious work that they need to get done in order to comply with the timeline, a requirement of the court, and then they sort of move on from it and forget about it. That's a dangerous tact to take. It is, for the case, one of the most important things that you can do is to understand what the person is going to testify to, and give a disclosure of what they're going to testify to, what those opinions are. And to be looking at that as you're thinking about their testimony, as you should be doing certainly now, even though it's months away from trial, on a continuing basis. So I would really stress the importance of that in a case, particularly of this import. You know, and so don't feel like your job is done at this point, because I would suggest to you it's not. That you may consider needing to do some cleaning up and making sure things are more fulsome in the scope of those disclosures and what you're doing. The other thing, you know, I think you tried to do to a degree is you thought, well, we think this is fact testimony, but, you know, in an abundance of caution, we're going to put it in an expert disclosure. Well, if you're going to put it in an expert disclosure because in an abundance of caution, it could be viewed that way, I suggest you treat it that way in terms of what you give. Okay. Thank you. And that goes to both sides. I haven't read your disclosures yet, so I don't know, you know, where that stands, but certainly goes to both sides. And I know that also, you know, the rules are different as to what the defense has to disclose necessarily and what the state does to some degree. And so
Thank you, Jen. Love you.
Well, I think the court will anticipate that there's a rather large filing that contain a lot of actual reports. Your Honor, listening to the court's comments and understanding where we were a moment ago when we spoke, I feel like I must go through what their disclosures were because there are so many lists. My hope was that they would be limited because they didn't fulfill their disclosure requirement, and we did, and that put us at quite a disadvantage, not knowing what their experts would say.
And if they supplement, you certainly can supplement based upon what they supplement, and I will permit that, and that's kind of the nature of the beast.
I do appreciate that. And should that become necessary, we'll definitely take you up on that, Your Honor. I want to make a record about some of their expert disclosures, though. All of the lab people, they have lab reports and notes. The Idaho State Police Forensics Lab, I better be really clear on that. Other than the wiggle room language, which would ask that they not be permitted to have any wiggle room language, the lab reports are fine, with the exception of one of the witnesses, Ms. Nowlin, that they've disclosed, and she's written no reports.
Is that the one they said is a rebuttal witness?
They said she might be a rebuttal witness. So I suppose now they know what our witness is going to say. I want to talk about the CAST report. The court's heard a lot about the CAST report. When I say CAST report, that's because that's what it's called. It's really a PowerPoint presentation. There's not any analysis in that. There's just, this will be my testimony. This is what it's going to be. Without much more, it's a picture and it has some dots and some arrows. Your Honor, that needs to be cleaned up. We need to understand the analysis that went into coming up with those PowerPoint presentations. That's just not plain good enough. I would let the court know that the cell phone experts, there's wiggle language in both of those if the court hasn't seen that. Their disclosure number, that's a Mr. Cox. That's a person that has not written a report at all. We have no idea besides the state's disclosure what that person's going to talk about. Agent Douglas that I talked about before, I don't think I need to make further record. There's a lot of documents, no analysis, no opinion stated. We put several of these in our pleadings, and so I won't go through all of them. I'm highlighting the ones that we're really concerned about. We have 3 that looked at digital data. The court should understand there's 60 some devices. There's digital data from third-party sources, and there are 3 people that are listed with just lists of things. It's Mowry, Tanzola, and Uri. They have lists of devices or social media accounts that they're going to talk about. That our expert told us would take 3 years to look at every bit of the data. So having no clue what's going to happen, I can envision exactly what the court's fear is when we get to jury trial, me wondering if this particular thing was ever disclosed. So I definitely needed to make a record of that. Further with the lab personnel, there's a caveat that says they'll talk about other people's reports and other things that are outside of their report, in addition to some of the other wiggle language that I referred to. Your Honor, given that the state is now cautioned to think about those things and submit more, I feel like it's important for us to bring out that we have a right to confront the evidence that's brought against us. Bryan has constitutional rights, United States and state of Idaho constitutional rights for a fair trial and to confront evidence. The expert disclosures are designed to advise us of what the state is going to do. Their disclosures were insufficient. I appreciate what the court said, but exactly what the court's worried about will happen if we don't have better disclosures. The jury will be in and out while we make sure that we have a clean record. We appreciate what the court said today, and we'd ask the court to order the state to comply or for the court to exclude anything that hasn't been disclosed so far. That's it.
So I'm going to give like both sides an example of what I expect. So you understand, there's been talk in this case about DNA. If somebody's going to talk about DNA and your intent is they're going to let the jury understand what DNA is, and essentially going to do a mini course on DNA, I expect to see that in the expert disclosures. Not that they're going to do a mini course on the DNA. I expect to see the mini course in the disclosures, if that makes sense, in terms of what their opinions are, what their information is that they are conveying that is expert in nature. And so it really does behoove both sides to spend the time to do that. And that's the last I'll say about that. It is probably
Specific.
the most critical
Specific.
thing that you have to do at this point prior to trial is to ensure that you have not just disclosed, but potentially over disclosed those opinions and what is required by the rule. All right, is there anything else with respect to those?
Your Honor, is the court giving the state a new date to fix their disclosures?
I'm not giving either side a new date. You understand, I think, what I expect. So you can choose to try to supplement those.
Or it's not getting in.
If they are simply expansions of what it is that they've disclosed that are just being more fulsome, I'm probably not going to have a problem with that given where we're at in advance of trial. And then defense certainly can look at those and decide that they want to expand or change or whatever their opinions are based on that. If it's whole new stuff, then you're going to have to demonstrate to me, new opinions, new lines, or even new experts. You're going to have to demonstrate why you didn't get that in the timeline.
And this is all discretion, and this is all error with
Is there
appeals.
anything else that we need to take up today?
Nothing from the defense.
Ashley's like, I gotta get to the bar. Hold on. We're good. Oh my God, this is gonna be a full day, man. I'm ready to take my half day.
I don't know whether we're going to have a Frank's hearing or not. I need to go and do that. But if you don't mind emailing some dates that you have available in the next, say, 3 weeks to do that in the event that we need to do it, I would appreciate that. Okay?
I think that's a great
All right. Well, I appreciate
answer.
everybody's, work. Not just for
He verbalized and said he did not deny it.
you know how busy you all are, and I hopefully have not taken more of your time than is necessary.
This is really good for the defense.
All rise, please.
You guys, that's a win for the defense right there. No doubt about it. Everybody's expecting this to be an automatic denial. Well, there's your automatic no denial automatic at the table. So I think that the Payne and Mowry would get the weakest link award. And the chain of custody would start with them. This never left MPD jurisdiction. So for them not to know what's going on that's impossible. Absolutely impossible. They are calling the shots. It's their case. For them not to know what's going on, that's not an acceptable answer.
No, we're like, oh my God, there's
and they score again. Blake Lively's getting sued. What is it? 400 mil? Jeez. Whew. Jeez. Okay. Let's go back and take a look really quick at some of this. Mr. Cox, he does not have a report at all. Figures. So Mr. Cox, how was he even going to be able to testify for the prosecution? Nick Balance's generic slides aren't going to cut it that he did in the Lori Chad Daybell case, that shit that you've done in the past, Balance. Yeah, Vallow, Lori Vallow, Daybell, whatever she's a damn psychopathic lunatic. I'm glad that I don't know what her name is. That stuff that Nick Balance did, that generic slide shit, his outdated cast from 2008, that shit ain't gonna slide. So let's see. To hear that they have 67 devices and their expert disclosed to the defense that it would take 3 years to look at all that data. And so if you're not going to be very specific of what you're using from those 67 devices, you have to disclose that. I think Hipper made it pretty clear, this is not going to be trial by ambush with the experts. And it shouldn't be. I think it's interesting that Ashley Jennings wants to say that the defense was taking the Hippler down a rabbit trail, as she said in quotes, rabbit trail. Your investigators not knowing the case isn't a rabbit trail. The scope, basically, how are you going to be able to question Mowry and Payne and say, hey, you didn't say, all of a sudden now you remember stuff, but when we did a suppression hearing, you didn't know those things, you didn't recall those things, you weren't involved in those things, or it was all groupthink. I don't know, you're going to have to go talk to this Douglas guy or that person. No, that's so what is Mowry and Payne going to be able to testify to at trial? Nothing, but they're going to be able to they're going to get royally cross-examined like crazy. It's going to be like a Proctor times 5, because everything that you saw in the Karen Reed case is going to happen with not just a Proctor type situation with one person, but in this case, you're going to have so much of it, it's not even going to be, that's what I think of that. How does somebody not remember they had conversations with Google through a chat system like we can all do? beyond me. That maybe these people need an early retirement and get into the assisted living homes. I mean, I want to know what they were doing from November 13th until the name Bryan Kohberger came up. We're going to find out at trial. We're going to find that out at trial, but we have no idea what they were doing as far as an investigation. I think that they were just running around collecting people's DNA and collecting people's cellular phones. So, but yeah. Let's see what else. A lot of memory issues in Moscow. Let's see what Chad had to say about the hearing. Karen, thank you so much. They're $999.99. Appreciate that. I think somebody, where was she? Donna, somebody bought somebody 50 memberships. I was trying to find that one. Thank you. Atlanta is the best. I love that comment there. Truth shall prevail. Every time I see Kaylee in the opener, it breaks my heart. Yeah, it's really sad. Okay, 1-800-Flowers. Did we reach that goal? I know Carson keeps a pretty good eye on that, to call the flower place here. I told you guys if we reach that goal, did we reach that goal? Was it close? Then I'm going to do a phone call. So, yeah, Idaho's water must run all the way to Indiana. Exactly. I think it's all the I states, that we really need to be careful. Idaho, Indiana, they just violate your rights, and everybody's getting flowers. Not flower close. Well, it's a Friday, so close on Fridays. We were expecting like a whole day worth of the hearing though, so yes, I agree. Anne needs to err on the side of caution, not to give up the defensive strategy, etc. 100%. That's exactly what was happening at certain points, and I think I understood that. I think how do you continue to question people that say I don't know? I would have called in. I think there was strategy though to not call in Nick Balance, and I think that's strategy. I got to thinking that after I heard the testimony yesterday, you're going to hear it first here, that I believe that the defense went after Dylan's health records, medical records. If Dylan has if she's been diagnosed with anything with her memory, or something has happened to her in her life that she has memory issues, I believe that would be one of the things that was sought after by the defense, if that in fact is like a real thing. And if you go back and look through all the different, if you go back and look at the docket, I know the defense went after somebody's medical records. So, and I would believe that would be, I'm putting my money on that. One of those would be Bethany. Yeah. I think we kind of are going to hear a reoccurring theme here, which is, I don't remember. Well, who is going to prove the case for the state if everybody that we heard from doesn't recall and they don't remember? So who is going to prove and meet the burden beyond a reasonable doubt? Because right now, the only thing that I've heard about is a sheath that's in the house that has touch DNA on it, and that by a secret way of making this all connect, the FBI violated all of our rights. They violated their own DOJ policy, not once but twice. Payne lied in an affidavit or since they call it group think, and everybody lied then in it because everybody knew that it was a lie, all the different things that were in there. They did not find Bryan Kohberger on November 28th or 29th. They acted like they did to the magistrate. They acted like they did all these investigative, we got his name and then we crossed our T's and dotted our I's. That just didn't happen. And now I think you made it worse when you were incorporating that every single person was aware of this. 100 to 120 agents worked on this case, and they all had that working document. Yeah, right. Get out of here. Who's buying that shit? Who's drinking that Kool-Aid? Because Truth and Transparency is not drinking that Kool-Aid. Absolutely not. You're going to have to give me 3 sheets to the wind to believe a damn thing that was coming out of the mouth of Ashley Jennings. But I think she blew off their legs yesterday, and then Payne blew off the right arm, and then Mowry just blew off the torso. So collectively, just like how they investigated this case, is collectively how they talked themselves into a Franks hearing. And if there's ever a case that would need it, at least in the Delphi case, these people in Delphi were at least lying with having they weren't saying things like, I don't know, I don't recall. They were just making shit up at least. And then the defense would have to go down, track down those lies, and then try to come back to court and say, this is what this person said in a depot, and then it's this. These people, so by whether you want to say that you're a liar by omission, or you're a liar because of what you're saying, you're just a liar. And there's no shame in this. And this is the government. And no, the ends does not, I'm sorry, but for me, people ask me all the time, well, but they got the guy. They would have never got the guy if they didn't do this. So the ends justifies the means, right? Well, then you don't know, then you have no idea what the government's all about, and you have no idea what our rights mean, and you have no idea what it's like to be falsely accused of something. And there's people that went to prison. The Innocence Project exists because of it, because of the faulty work of law enforcement. And now we want to give up even more power for them to just write blanket warrants out and get whatever they want, whenever, on whoever, for whatever. So we're going to be continuing to grow as far as technology. Our phones hold everything. We don't keep, file cabinets anymore with all of our here's my birth certificate, and then here's all my bills. Here's my, that's not the way the world is anymore. So everything used to be a value that was in our house. Okay. That's not how it goes. That's not how our phones have all of our information in it. Our phones, if you're a parent, have your spouse's information in it. If you take care of your mom or your dad, grandparent, your kids' information. Okay. We are so tech heavy, and the Constitution, and that's what Jay was saying there at the end. Jay was saying that there's going to come a point in time here, and someone's going to be the judge that is going to have to start making some of these calls, because we're going to get to the point that we do not have any privacy then. There is no such thing anymore as privacy. We will never have we won't have privacy rights ever again if judges don't start changing. But in order to obtain the name and to ever look into Bryan Kohberger, the Idaho State Police could not do anything with the IGG when they sent it to their contracted lab. It came back with no results. They couldn't do anything with it. Then all of a sudden the FBI gets it, and when the FBI is handling it, it doubles in size with the SNP profile. And then there's no information of whatever they did, that it miraculously produced this name. Here you go. Okay. But 2 things are for certain. We at least got the fact that they violated the consumer policy and they violated their own DOJ policy, but not once, but twice, because they used two databases that were not allowed to upload kits against law enforcement exclusions. So, and for me, if we're making our second graders and our third graders and our college students and our high school students show your work to earn your grade to be able to pass and go to the next level, then how are we not making people prove and show their work if you want me to put to death a motherfucker? Are you insane? You want me to vote guilty and kill somebody off of you don't have to show me your work? Have we lost our minds as Americans to let the government get away with this? And I know that I have not lost my mind, and I won't lose my mind. Sheldon Jeter Jr. is sitting in a prison right now. He's innocent. If he had 1/100th of the defense that Bryan Kohberger has right now, he'd be a free man, a 24-year-old free man. They want to kill Bryan. They want to kill him. They don't have to, and they could answer the way they answered today on the stand. That's not okay. That's just not okay. And it doesn't mean that I think Bryan Kohberger is innocent. It means that I'm not okay with what's going on in the government. And so guess what, government? You're going to watch Bryan Kohberger for the rest of your lives to make sure that he doesn't harm anybody, because you guys all fucked it up if he was the killer. But I'm not going to vote guilty on this shit. And people want to say, well, why would Ann Taylor want to suppress anything if there's nothing there anyways? Then you don't get the point. Then you don't get it. You don't get it. Even if none of this stuff has any returns on it, you do not. Lawyers are supposed to be there to protect our rights. So are judges. And actually, so are prosecutors. And so are police officers. But right now, all I see is a bunch of prosecutors and police officers violating our rights. And when I say police officers, I'm talking about the FBI. I'm talking about Moscow Police Department. They're just acting like they don't know what the hell's going on. Meanwhile, Maury was sitting right next to Balance, and he doesn't know. I don't know anything. Unbelievable. It's disgusting. But I'll tell you what, everybody and their motherfucker saw this motherfucking bullshit today and yesterday. And I hope a lot of people start appealing a lot of cases over there in Moscow, Idaho that went through that department and that county. Much love. Here we go. We got to get, we got new members. We got people buying memberships for each other. So we're going to make a phone call here. We got to get some flowers on over to, you got Ann Taylor's address over there. We're going to make a phone call here. How do they sleep, right? Yeah. How do they sleep? We rock over here at TNT. We're going to go. I agree, Joker, with that. It'd be nice if bigger channels were more constitutionally oriented. Yeah, Bryan Kohberger is constitutionally innocent right now. He's given that constitutional right. You're innocent until proven guilty. And Ashley Jennings wants to just walk up to the podium every time like she's, I don't even know. But I will say that if you guys want to see a good, what Where's our girl Ash? Yeah, here it is. I want to see Ashley walk herself into a Frank's hearing. So here.
Now, if you can answer yes to that, then
Okay, here we go. This is Ashley. This is when Ashley just walked herself into a Frank's hearing.
made a substantial, not just a preliminary.
Okay. And I'm getting the number right now
The other
so that we
thing,
can call 100 Flowers.
I think I covered all on my proffer, Your Honor. Thank you.
I think, now, Ms. Meyer, were you going to address the IGG Franks issue, or is Ms. Jennings going to cover all of it?
Ron, I think I'm going to cover all of it.
All right, go ahead.
Gonna attempt to.
Ashley Jennings, welcome to the game. Shake it for Ashley. Shake it for Ashley.
Good afternoon, Your Honor. As you're well aware, you have to make two separate inquiries for each of the claims that Ms. Taylor has brought before you. First, you have to decide today, has the defendant made a substantial, not just a preliminary showing, but a substantial preliminary showing that the affidavits, and in our case, we're referring to the Exhibit A's that were attached to each of the affidavits for probable cause, that they were the basis, which were the basis for multiple search warrant applications, that within those Exhibit A's, there were deliberate or recklessly false statements or omissions. This is a high burden, and this is a very high hurdle for them to jump over. Now, if you can answer yes to that, then and only then should we move on.
Then and only then should we move on. Well, yeah, I think there's some definitely I think you got to give them check for that. Okay, so let's go ahead and say that they did that, Ashley.
And then ask the second question.
Okay, two-pronged.
Does that even matter?
Does it even matter? Because is it material? Is it material? Okay, so does it even matter? Does it even matter?
That statement actually diminished the probable cause finding. It's only when the answer to both of those questions is yes, should you then even consider granting a Franks hearing. The motion for a Franks hearing is a serious allegation. The allegation is that law enforcement acted improperly, that they lied to the magistrate in order to secure the warrant. The statements have to be deliberate, reckless, false.
Well, what if the people that are writing the warrants have no idea what they're writing? They have no idea what they're even asking for. They don't even know what's going on, right?
That's the standard. Franks is not implicated by just simple mistakes or misunderstandings about the evidence or Scrivener's errors or even just negligence. As the court is well aware, this is serious. The defendant is alleging law enforcement lied to secure the probable cause in this case. And the state submits the defendant has failed to back up this claim. And they failed because they can't. Law enforcement submitted probable cause affidavits to the magistrate based on the information they had available to them at the time that the various applications were made. That's how it's supposed to work. And that's how.
And now Judge Hipper's going to ask himself, did they have more information clearly available to them because it was a group effort? If everything was a group effort, then they most certainly had way more information, right? They just testified today who they were getting their information from.
That's how it worked. The defendant has alleged 13 separate areas where they say there's a Franks violation. I'm going to go through those so that I make sure that I get through each of them in the same order that defendant addressed them in their motion and as the state addressed them in our response. And that starts with this idea of attacking Exhibit A.
Exhibit A is Payne's statement, is everything, is the PCA.
Now, in Latah County, it's our practice, we submit an affidavit for probable cause. As I said, attached to that affidavit is what we call an Exhibit A. That Exhibit A is law enforcement officers' statements, laying out all the various facts known to them related to probable cause in order to support the issuance of a search warrant. In this case, Exhibit A, by the time we get to where we're challenging, was about 20 pages of facts for the magistrate to review. Essentially, the same Exhibit A was relied upon for the application of multiple warrants. This was a massive investigation. You heard testimony earlier today from Detective Payne. Multiple officers were involved in this investigation from multiple agencies. And they were doing briefings. For weeks at a time, they received 2 briefings a day with all the lead investigators in the same room receiving the same information. This information was then put into this Exhibit A for the basis of a probable.
They were being briefed 2 times a day for weeks, and they don't remember anything of what went on in this investigation.
Cause affidavit or search warrants. A working document like this, with the most up-to-date information, was the best way to ensure the magistrate was getting the most complete and accurate information. And defendant wants to take issue with this process, but
What do I do if the affidavit is attached to Detective A's submission? Is it Detective A's affidavit, right? And there's a, for purposes of my question, a material reckless statement in there. But Detective A isn't the one that made it. It was another person on the team, let's say the cast member expert.
well,
How does that affect the Frank's analysis as it relates to the affidavit submitted by Detective A?
I would say that Detective A would have to have reason to know that that was a materially reckless statement made by Detective B.
Even if the person that made the statement on the team knows that that statement going into the affidavit, that group affidavit, if you will, or the group statement is going to ultimately make its way to the magistrate?
I'll concede I think there's an issue there, but that's not what happened. I don't think that any officer can submit a statement that they know is going to go in front of a magistrate and do so recklessly. And if they do so, then I agree that the court should take issue with that.
Bingo. She just walked that right there.
But
do you see right there? That's when that, ladies and gentlemen, that is the moment that the wheels fell off the wagon. Right there. Because so then you look at today's testimony, and today's testimony by Officer Payne said that everybody would have known what was going. It was floating around everywhere. Everybody had a copy of that affidavit, right? Everybody knew what everybody was saying. But she says right here in her argument but that's not what happened in this case. Says who? Your officers are saying it. That's exactly what happened in this case. Like, it's curtains. It's over. Listen to this. She failed the test right here. I mean, it's black and white.
But the cooperative nature of this investigation and this kind of group effort is allowed. As discussed more extensively in the state's response, we have several Idaho cases that support this. State v. Rubio, State v. Gomez, State v. Aldra. And in our case, the probable was then put into this Exhibit A for the basis of a probable cause affidavit for search warrants. A working document like this, with the most up-to-date information, was the best way to ensure the magistrate was getting the most complete and accurate information. And defendant wants to take issue with this process. But
what do I do?
Here it comes.
If the affidavit is attached to Detective A's submission, is Detective A's affidavit, right? And there's for purposes of my question, a material reckless statement in there. But Detective A isn't the one that made it. It was another person on the team, let's say the cast member expert.
well,
How does that affect the Frank's analysis as it relates to the affidavit submitted by Detective A?
I would say that Detective A would have to have reason to know that that was a materially reckless statement made by Detective B.
Even if the person that made the statement on the team knows that that statement going into the affidavit, that group affidavit, if you will, or the group statement is going to ultimately make its way to the magistrate?
I'll concede I think there's an issue there, but that's not what happened. I don't think that any officer can submit a statement that they know is going to go in front of a magistrate and do so recklessly. And if they do so, then I agree that the court should take issue with that. But the cooperative nature of this investigation and this kind of group effort is allowed. As discussed more extensively in the state's response, we have several Idaho cases that support this. State v. Rubio, State v. Gomez, State v. Alger. And in our case, the probable cause affidavit, it wasn't as if the judge wasn't put on notice that this was exactly what was happening. The judge was put on notice. Each affidavit explicitly told the magistrate, blank officer, depending on who was applying for it, quote, is being assisted by members of the Idaho State Police and agents of the Federal Bureau of Investigations. Throughout the document, it makes references. I consulted with FBI Vehicle Specialist S.A. Eimel. I consulted with FBI S.A. Balance regarding cast. I consulted with FBI S.A. Hill regarding surveillance footage. It's very clear what the sources of the information were coming from. It could absolutely be reasonably inferred where the information was coming from. The magistrate was not at all misled regarding the sources of all the information. I'm going to talk a little bit about this idea that there's some issue with who did the work in reference to Google. They claim that the CSLI work alleges Kohberger around the King Road residence. And this same.
Do you hear what she just said as a whole right there? I mean, she literally in 2 minutes, literally, you could just play this on replay. She walks herself and her team into a Franks hearing. Because absolutely, these guys testified today, they don't know anything and they don't know who did what. And everybody knows what everybody did. It says it in there. Everybody knows what everybody said in their statements. What? Who knows what in this case? All I heard is I don't knows. And all I heard is I don't recalls. I don't remember.
If the affidavit is attached to Detective A's submission, is Detective A's affidavit, right? And there's for purposes of my question, a material reckless statement in there. But Detective A isn't the one that made it. It was another person on the team, let's say the cast member expert.
Well,
how does that affect the Franks analysis as it relates to the affidavit submitted by Detective A?
I would say that Detective A would have to have reason to know that that was a materially reckless statement made by Detective B.
Even if the person that made the statement on the team knows that that statement going into the affidavit, that group affidavit, if you will, or the group statement is going to ultimately make its way to the magistrate?
I'll concede I think there's an issue there, but that's not what happened. I don't think that any officer can submit a statement that they
That's
know is gonna go
exactly
in
what
front of a
happened in this
magistrate
case.
And do so recklessly.
That's exactly what happened in this case, though. She says, but that's not what happened in this case. Actually, it's exactly what happened in this case. And look at Masseth over here. And look at the two people behind the defense listening to this. Look at that girl's neck. My neck. My back. Watch the defense.
And if they do so, then I agree. That the court should take issue with that. But the cooperative nature of this investigation,
Cooperative
and this kind
nature.
of group effort, is allowed.
Yeah, we didn't say that. You're allowed to have a group effort, but you just can't lie as a group. You can't lie as a group. Lying as a group doesn't make it okay, Ashley.
As discussed more extensively in the state's response, we have several Idaho cases that support this. State v. Rubio, State v. Gomez, State v. Alger.
We have no problem working as a
And
group.
in our case, the probable cause affidavit, it wasn't as if the judge wasn't put on notice that this was exactly what was happening.
So the magistrate was put on notice, okay, that this is exactly what's happening.
Was put on notice. Each affidavit explicitly told the magistrate, blank officer, depending on who was applying for it, quote, is being assisted by members of the Idaho State Police and agents of the Federal Bureau of Investigations. Throughout the document, it makes references. I consulted with FBI Vehicle Specialist S.A. Imel. I consulted with FBI S.A. Balance regarding CAST. I consulted with FBI S.A. Hill regarding surveillance footage. It's very clear what the sources of the information were coming from. It could absolutely be reasonably inferred where the information was coming from.
Wait, what? Wait, did you just hear this sentence? It absolutely was known where the information was coming from. Really, Ashley? Because your people just testified today. They don't know the source. They don't know anything.
I consulted with FBI SA Balance regarding CAST. I consulted with FBI SA Hill regarding surveillance footage. It's very clear what the sources of the information were coming from. It could absolutely be reasonably inferred where the information was coming from. The magistrate was not at all misled regarding the sources of all the information.
Well, she clearly was, because your own the offendant doesn't know.
I'm going to talk a little bit about this idea that there's some issue with who did the work.
Okay, who did the work?
In reference to Google. They claim that the CSLI work alleges Kohberger around the King Road residence. And this same claim is in Exhibit A signed by Detective Blaker. Well, this is inaccurate. The officer signing the affidavit did not claim to do the CAST work.
Did you mean AT&T?
Yes.
Yes, I actually meant AT&T.
They didn't claim to have gotten those records and put them in to their program to determine the approximate locations of the phone.
Who did?
That was done by Special Agent Balance. And
how do you know that? How do you know that? Who did he tell you that? Ashley, did he tell you that? Did he tell you that? Because Payne doesn't know that. He said, I don't know what he did between 3:45 or 3:30 when I got them and 4:45 when I obtained the second one. I don't know what he did. He did whatever, and he just gave me this to go do that, to put into the second warrant. Remember? That's what he testified to today. So does Ashley Jennings she's a witness, you guys. She applied with Payne to get these affidavits or to get the search warrants.
The affidavit makes that clear. And defendant ignores the entire paragraph within Exhibit A that makes that clear. Quote, I consulted with an FBI special agent that's a certified member of CAST. This paragraph goes on to explain what CAST is, what CAST.
Wait, I consulted with. He didn't. So, but then you guys hear the testimony today. I didn't consult with anybody. I don't know what was going on between 3:30. She is insane. She is lying her fucking tits off here. Okay. Today's testimony prove this is laughable. Oh, it's funny that Ashley Jennings seems to know everything that was going on. But on the stand, when these guys are asked what's going on, they have Payne said, I have no idea what Balance was doing between 3:30 and 4:45 when I then obtained at 4:53 the second warrant. So how could he have consulted with Nick Balance? I mean, do they need me to like, when you argue something, you're making arguments. You have to remember what these people are saying, and then you're using what they say against them. So was Ann and them not hitting home enough on this? I mean, this is clear as day.
Does the experience that's involved, SA Balance's own experience, and then
the argument
law
is
enforcement
wrong.
officer then states, from information provided by CAST, I was able to determine estimated locations for the 8458 phone. That's not claiming to have done the CSLI work, but instead it's just a reflection.
No, he what do you mean? He's saying that I then made the estimations. Is this insane? Like, what the fuck? You know, I'm actually getting more pissed right now. He most certainly saying you guys, this is going to be a Frank's hearing. And I don't know, and maybe that's why Ann's, keeps on saying like that, well, this doesn't blow our right to reserve, blah, blah, and our, we're going to write up this and write up that. I mean, what's going on here? Like, there is no way that Hitler is going to be like, listen to what she's saying and look at his face. He's like, I cannot believe that she's oral arguing like this.
The work was done by balance. Investigators reviewed that, and then
Investigators reviewed what? She is saying, do you understand? These guys testified today. They didn't do anything like that. They didn't review anything. Nope, gave it right on over there. I didn't see anything. I don't even know what that data means. I mean, this testimony is not what Ashley Jennings is portraying at all. Does she not listen to her own fucking people? Oh, wait, that's right. That's why she had no questions for Payne, right? No follow-ups, no rehabilitation.
made some determinations of the approximate locations for that 8458 phone. And we're going to get into this in a little bit down because this comes up again.
Wait, who made these determinations? Who made these determinations on where the car was? Listen to what she says again.
I'm going to talk a little bit about this idea that there's some issue with who did the work in reference to Google. They claim that the CSLI work alleges Kohberger around the King Road residence. And this same claim is in Exhibit A signed by Detective Blaker. Well, this is inaccurate. The officer signing the affidavit did not claim to do the cast work.
Did you mean AT&T?
Yes. They didn't claim to have gotten those records and put them into their program to determine the approximate locations of the phone. That was done by Special Agent Balance. And the affidavit.
And so the defense is arguing that there wasn't enough time to do any of that. And there's not enough time to go through all that data. Okay. And to plot this and to know that the car is going, or to know that the phone had shut off or was turned off. And then it was it was facing, the opposite way. Like there was no time to determine any of that. Of what they said in the freaking affidavit. You understand? Everything that they wrote there to say that then we saw the car did this and the car did that and then did this and it's consistent with the phone's movements. There's no time to do any of that when you're applying for the next warrant and you're adding on to that probable cause warrant by saying those things.
That makes that clear. And defendant ignores the entire paragraph within Exhibit A that makes that clear. Quote, I consulted with an FBI special agent that's a certified member of CAST. This paragraph goes on to explain what CAST is, what CAST does, the experience that's involved as a balance's own experience. And then the
argument that
law
they're
enforcement
wrong.
officer then states, from information provided by CAST, I was able to.
From information that was provided by CAST, I was able. She just says right here, what a moron. I mean, what a complete fucking moron Ashley Jennings is right now.
To make determination, I was able to determine estimated locations for the 8458 phone. That's not claiming to have done the CSLI work, but instead it's just a reflection. The work was done by Balance, investigators reviewed that, and then made some determinations of the approximate locations for that 8458 phone.
Yes, you stupid fuck. Exactly, Ashley. That's what you're claiming. And your investigators testified today to nothing of the sort. Your investigator testified today as I don't know any of that stuff. I didn't even open up the file. What is up, business pots in here? Look up. You guys, what? This is when the wheels fell off the wagon on January 23rd, 2025.
and we're going to get into this in a little bit down because this comes up again, all about the cell phone. And we're just going to take we have two different opinions about what those records show. We have an expert who tells us, and that's what was relayed in the probable cause affidavit. And those opinions haven't changed. We differ on a few factual issues. I believe there are 3 towers that provide service to the Moscow area.
Oh God, you see his hand movement up? He's like, oh God.
Defendant is cruel.
Oh, you see Hitler? You see Hitler?
Here's my concern with you telling me that at this stage of things. Where in the record is that currently? Apart from anything you may have submitted after they filed the Franks motion.
What specifically?
That there are 3 towers.
I believe I referenced it in my response.
Yeah, but if you give me evidence and I rely on that evidence, then I have to give them a full Franks hearing. And
You hear? You hear? You hear? What did he just say? Then I have to give them a full Franks hearing. When did you give me that information? In my reply.
so that's why I've been very clear to say I'm looking at what the proper is from the defense without evidence submitted by the state to determine whether they have met their threshold burden. And so I get concerned when you start telling me things that are not necessarily part of the evidence.
Understood. We can move past the number of towers. Here's what is in evidence, though, and based off of the PC affidavit.
Okay, what is? Tell us, Ashley. Keep those fucking wheels running, baby.
Is that the phone was in the area for the tower that provides service to the 1122 residents.
When?
Still maintain that's true.
He still maintains that that's true. When? Wait. Ready? One more time right here at the end here, Ashley. Wait, can you repeat that right there?
After they filed the Franks motion.
What specifically?
That there are 3 towers.
I believe I referenced it in my response.
Yeah, but if you give me evidence and I rely on that evidence, then I have to give them a full Franks hearing. And so that's why I've been very clear to say I'm looking at what the proper is from the defense without evidence submitted by the state to determine whether they have met their threshold burden. And so I get concerned when you start telling me things that are not necessarily part of the evidence.
Understood. We can move past the number of towers. Here's what is in evidence, though, and based off of the PC affidavit, is that the phone was in the area for the tower that provides service to the 1122 residents.
When? Because it was not on the night of the murder. You guys know that, right? Like, what is she talking about? That phone did not hit on any tower that provides service to the 1122 King Road house. Do you guys know this right here, right? What the fuck you talking about? This is insanity. The PC affidavit said that it was not in the area.
Still maintain that's true.
And Taylor's face is like, well, now Ashley Jennings is saying that I guess the FBI is saying that Bryan's phone was on the towers during, like, when? Never. They've never on the day of the murder. She is talking about the 12 pings. She didn't specify that at all.
Regardless, none of this has.
Regardless, I'm losing my mind, right? She's like, I'm losing my train of thought. What am I even talking about?
Any bearing on
None of this has any bearing.
Validity of the search warrant.
Of the validity of the search warrant. Wait, what? The validity of the search warrant? The validity of the search warrant is most definitely reliant upon the truthfulness of the PCA, right?
Their argument is merely a clarification about which member did what work.
It's merely a clarification of which member did which work. According to your people's testimony today, Ashley, nobody knows anything. And they're swearing under oath that they plotted stuff and they don't even know how to do that.
And that doesn't matter to the
Look at his face. He's like, no, the wheels are off the wagon now.
Determination for probable cause. Defendant then make some allegations regarding an eyewitness statements related to DM.
Okay, let's find out about this.
There's kind of two buckets of attacks here. The first bucket is that the defendant claims the magistrate was never informed that DM told law enforcement she, when shown a picture, didn't recognize the defendant.
She was shown a picture. Thank you.
It's clear from reading the probable cause affidavit that she's not going to recognize the defendant.
Wait, it's clear from reading the probable cause affidavit that she is not going to recognize the defendant? Where is that clear? Where was it clear that she was ever shown a picture of the defendant? Oh my God. I don't even...
What relevance was the statements of DM that were included in the affidavit as to probable cause?
Okay, here we go.
I cited those in my response throughout. She was.
What were they?
Okay.
What were they?
I can
Well,
tell
she's-
generally.
She doesn't. Let me go grab my brief. You guys, we on this internet know way more about this case than these people know about this case. It's just crazy.
Listen, she gave the same set of facts.
I understand the things that she said. Why was it important the magistrate know those things?
Yes, now we're getting to the good questions. Why was it important for her to know those things? And Hitler knows what the importance is. And this broad argues it the wrong way, which tells me everything that I need to know. The importance, like I've said on this channel since day one, where DM's statements are so important is for the timeline, the time of the crime. Listen to how Ashley argues it.
In other words, are they going to who the idea of the perpetrator is? Are they
She
going to-
doesn't know the answer. She doesn't. We are just putting anything and everything in this probable cause affidavit.
establish a timeline of when the alleged or when the murders took place?
Yeah. Both.
So it's part ID as well?
I think that it goes to giving a general description of the person that she saw in the residence.
The general description of the person she saw. Excuse me. She didn't. Oh God.
Around the time that corroborates when we know these crimes occurred. Yes.
Wait.
general description
Wait.
is material
When we know these crimes occurred, you don't know when these. How do you know when these crimes occurred? Were you there?
in that material, in that general description, which is what was provided in the PC affidavit, was consistent throughout all of her interviews. She described seeing someone wearing all black, a mask with only a portion of their face showing and visible. This person was male, white. She heard a voice that was not someone that she recognized. The person was a slim, skinny, lean build. And the person was taller than she is around 5'8". That's what's
5'8".
It was that general description. And that general description did not change.
What kind of
establish the timeline?
Right there, he knows. He knows. Wasn't it also important to establish the timeline?
It's important to establish the timeline to know when that the timeline matched the vehicle surveillance of when a suspect vehicle is coming into the area of 11:22 and then leaves, as well as text communications of her relaying what she's observing during the same time period.
So right there, she says exactly what I thought she said. You guys, this does not mean that Bryan's the person in that car. You understand? And so DM is texting, okay? And it sounds like everybody's alive. You can argue that everybody was alive at that time. DM had no worries. She would have called 911. She wasn't frozen. She wasn't frozen. She was texting what she saw and heard and all the stuff. Surely if it was the killer that walked by her, right? They would have killed her. This is insanity. But he gets it. There's no way I can boost the hearing. It's all the way up. You guys should know this. I mean, That's how they have it. I'm not turning it down.
And, and
Earbuds.
even if the state's wrong, that somehow there was some exculpatory relevance to some of her statements not being included in the probable cause affidavit. You can take all of it out and the magistrate would still have probable cause.
How? How would the magistrate have probable cause if you take out all of DM's statements? You have a car coming and going from that area is irrelevant without DM statements. Because there was plenty of cars coming and going from that area at different points in time. The ME can't label the time of death to pinpoint when. I mean, like, do you hear how crazy that is? DM statements are needed because if they weren't, otherwise they wouldn't be put in there if they weren't needed. Because you're associating certain times. At 3 a.m., at 4 a.m., I woke up, got out of my bed, went back down, got out of my bed, opened up my door, all that bullshit. This is a novel, man. Exhibit A is a novel.
The second issue defendant, the second kind of bucket that they take issue with DM is about these other just statements that she gives during her interviews. The defendant argues when an eyewitness states she's not sure anything she saw was real, a magistrate should know about it. Well, the simple answer is investigators knew what she saw was real, and we know it wasn't a dream because they found the evidence discovered the next morning. Those statements didn't need to be included in the PC affidavit because they weren't exculpatory. They didn't support this idea that this didn't really happen, that somehow we got it wrong. Next, defendant attacks the vehicle identification.
I mean, I can't even listen to this broad. Unreal. Unreal. I mean, this is when Ashley Jennings just totally, like, she is walking them into a Frank's.
Well, this picture they're painting about how this happened just is simply not true. The magistrate was given a very detailed picture of the investigation at the time related to the white sedan, which was later determined to be a Hyundai Elantra. This was about 5 pages of the probable cause affidavit. The reality is, still images and video were provided to a vehicle specialist. Based on his review, he provided information to investigators that the suspect vehicle was likely a Hyundai Elantra. There was some discussion regarding what was the most appropriate year range, but at the specialist's direction, he said that the year range to be focused on was 2011 to 2016. So Detective Payne reasonably relied on his expertise as a vehicle specialist and included
Right there, she lied.
that in his probable cause affidavit. And the court has in front of it the emails attached as exhibits that show that's exactly what occurred. And the defendant appears to argue that, well, the vehicle specialist shouldn't have relied on this video because they can't tell that that was a Hyundai Elantra. To them, it doesn't look like, I guess, a Hyundai Elantra. And the video that is clear, well, they take issue with that video because, and specifically we're talking about 1125 Ridge Road, because they say, well, that can't be surveillance video of the white Elantra, even though it was caught on video about 0.3 miles from the crime scene, about 3 minutes right before when we see the suspect vehicle enter the area of the crime scene, which 0.3 and 3 minutes appear to be the amount of time it would take the vehicle to travel to the area of the crime scene. They say, well, that can't be the right video because if it were, then the surveillance right up the street would have also caught this video. But we know that's not true. And that's been submitted to this court. Excuse me?
When was it submitted to this court?
Well, it was submitted through my response.
I was afraid that you were going to say.
I was afraid that that's what you were going to say. The response, like the replies.
It was submitted through my response that could that their logic is flawed. And I can tell you, it has since been confirmed. I do not have, and it has been discovered to defense. We had Special Agent Hill confirm, and he discovered this as Bates 15990, which confirms that the surveillance camera that was set up to capture motion would not have captured the corner the defendant says must have been necessarily captured. Again,
This is all hearsay. Submitting this like this.
it doesn't matter. At the end of the day, the defendant's speculation about the route of travel and their different.
Wait, who's the defendant? Isn't speculating the route of travel. You guys have speculated on all those routes of travel.
Opinion on it isn't the basis for a Franks hearing. There's no legal basis for second guessing a vehicle specialist's opinion, and they haven't made a substantial or a sufficient proffer for you to do that.
No, actually, you have. You've done it for us. Thank you.
Next, the briefing addresses the IGG issue. And
Is it possible to tell from the affidavit what shots and what cameras were relied upon to make the identification?
I know that I don't know that you needed to. I don't know that all of that information had to be included.
That wasn't my question. My question is whether the affidavit describes the specific shots and cameras relied upon to make the identification.
No. It discusses that several surveillance videos were reviewed, that images were turned over to a vehicle specialist, and then that specialist made a determination. But no, we didn't walk through describing each and every still image or video to the magistrate. No, nor did we need to.
Well, he's going to determine that. Nor did we need to.
Really, the IGG has been discussed extensively. I think the only real Franks issue is, should the IGG process, the fact that it was not included in the PC, is that the basis for a Franks hearing?
That's not what this is
But
about.
you heard testimony today that law enforcement received this tip and they made a strategic decision not to include it. They were told it's only a tip and that they should develop probable cause separately. And that's what they did. And at the end of the day, Your Honor has already kind of hit the nail on the head through your questioning of Ms. Taylor. At the end of the day, this information regarding IGG and the use of IGG is only inculpatory. And the non-reliance.
No, it's not only inculpatory, because if it was planted, and this is where the wheels really fall off.
On the IGG information does not diminish probable cause. And the IGG information was confirmed through the STR testing. I can't wrap my head around any argument that IGG and STR testing would be exculpatory. Defendant makes kind of hay about the dog barking.
Here we go.
And that I guess the magistrate should have been informed that a dog barked for 25 to 30 minutes. And this is just a reach for me. I'm still unclear how this is exculpatory. And again, this fact just does not diminish. Take out all information related to the dog. It doesn't diminish probable cause.
Take out all information about Dylan, right? Who said that Kaylee was playing with her dog, right? So let's just take out the dog barking, okay, which they're using to establish time of the crime. They're using Dylan to establish the time of the crime. But let's take those things out, she's saying. And so he is going to use this in his how he orders, how he rules. And Ashley Jennings saying to take all this stuff out, what do you have left? And you don't have probable cause.
Circling back to the cell phones. At the end of the day, this is the proffer is their opinion of the evidence. That's not the basis for a Franks hearing. We're relying on our expert's opinion. They disagree. And that is a dispute that should be had, and it should be had at trial. And I suspect it will. But it doesn't give you the basis to grant a Franks hearing.
The audacity of this fucking broad.
Defendant the next area is the footprint. There was a footprint found outside of DM's bedroom. They claim that the inclusion of this was misleading, But again, there's nothing misleading about the statement. The statement says during the process of the crime scene, the investigators found a latent shoe print. It was located during the second processing. It came back using a presumptive blood test and showed the presence of cellular material. They let the judge know that it was outside the door to DM's bedroom located on the second floor, and it's consistent with her statements. Yeah. The investigators provided the magistrate the information they had at the time of the investigation. Defendants' opinions about where the shoe print should have been located and it couldn't necessarily have been located there, again, that just doesn't rise to the level to warrant a Franks hearing. Again, our case doesn't hinge on the identification of the shoe print. Neither did the PC affidavit. There was sufficient probable cause with or without this information.
See, she keeps saying that. With or without this information. She's chopping off her probable cause affidavit.
I'm going to address grand jury subpoenas. They didn't discuss it today, but it's addressed in their.
All right, guys, what do you guys think about this? I mean, truly, they're like, Bella's like, Lana, will you just be objective? I'm like, I'm always objective. What are you talking about? I'm like the most objective motherfucker out here. And she's like, no, seriously, be objective. And I'm like, okay, sweetheart, this is my objectivity. I would rather go pro se than have Ashley Jennings represent me ever in my life. That's my objectivity. Did she practice this with her peeps? I don't know. I feel like I need to whip out my 2021 hearings that I did as a pro se litigant for my first time. I don't know. I just wouldn't want her representing me. Her peep, she's like, hey guys, why don't you listen to this? I'm ready for this. I'm ready for Ann Taylor's arguments, man. I got this. Well, somebody told her to sit the fuck down today and don't say a word because that's what happened.
Motion.
Yes, before you get to that, can you address the allegation that the cell phone data was, I guess, purposefully erroneous as to the time that the phone was no longer reporting, which then relates to the supposed position of trial?
Well, I don't know that I completely wrap my head around the defendant's logic in this.
I have to, so help me out.
Well, I still don't understand.
I understand her statement and her argument. I'm trying to understand your response.
I guess what was reported was the information known at the time that the probable cause affidavit was given.
There's Payne, or by
the information that he was given from.
This goes to my first question about imputed erroneous statements. So I understand the allegation in that regard, not necessarily to be that Detective Payne knew the statement was wrong, because I'm not sure there's evidence of that. But did the CAS specialist know that there was a misinterpretation or an erroneous report?
I don't think that you have before you a sufficient proffer that proves that the CAS specialist submitted false information. Apparently, there's a difference in the handoffs of 7 minutes. At the end of the day, okay. No, I don't think it's incredibly material.
What?
Look at it in terms of where the phone was in that 7 minutes.
Well, it's material.
Going a direction different than what your affidavit says it was going. Isn't that material?
The direction of travel, like, yes, I would say it was if it was found outside of Pullman. It was not. It was reporting to a tower in Pullman. This assumption assumes that cars can't change direction of travel. We're assuming that then the same cell phone, which was then turned off, isn't then also tied to the evidence.
That's what we're saying.
Information to believe a white sedan tied to Mr. Kohberger has been found on surveillance.
She just
We're
choked.
not talking about 7 minutes. We're talking about 7 minutes at 2:50 in the morning, which is about an hour, approximately a little over an hour before the crimes occurred. I don't follow the logic that
You have the car on camera
this
at
7 minutes,
3:27.
an
It matters.
hour and 10 minutes prior proves that there's no way the defendant couldn't have traveled the 7 miles to Moscow, whether or not the car was pointed in a different direction or not. It's a leap.
You just told them that your PC is a lie. You just told them that.
Does that answer?
No.
Well, it's your answer. So.
It's your answer. Yeah, bitch.
Let's say it was.
She wants to
Let's
continue on.
say that it was exculpatory. Let's say it was materially that it was false. It was recklessly included. It wasn't, but let's say it was. Well, the magistrate still had enough information before her to grant probable cause for the arrest. So we still don't get to a Franks hearing, even if you want to make that leap.
The University of Idaho graduate. The University of Idaho graduate.
I can quickly go through grand jury subpoenas. At the end of the day, their desire still, this has come up several times throughout this process, their desire to see the actual grand jury subpoenas is not the basis for a Franks hearing. There's just simply no legal basis to support that idea. And there is nothing obtained that was obtained in violation of any of the defendant's constitutional rights. They say they needed to know the scope, but it is not clear to the state how that would have made any difference in the probable cause determination or why the magistrate would need to know that. Again, this just appears to be another attempt by the defendant to try to obtain these federal grand jury subpoenas. And I submit to you, Franks is not the proper avenue. We're going to go to lack of connection. I think this has already been addressed by Your Honor. At the end of the day, this fact just has no bearing on the probable cause determination. The investigators relayed the known information they had at the time, and timing is important. At the time of the application of most of the warrants, the evidence taken from the defendant and his vehicle was still being reviewed. We didn't know if there was a connection. Only a few warrants even fell outside of that. Apple, YouTube, Instagram, TikTok, PayPal, and Microsoft. However, even for those warrants, the state submits to you that fact's not necessarily exculpatory. The defendant's belongings and the vehicle were recovered approximately 6 weeks after the homicides. And that fact was known in the probable cause affidavit. It could be reasonably inferred. But to the extent the court believes that law enforcement should have included this information, again, I can accept that, but it's not enough to outweigh the balance of the information that was included that did establish probable cause.
Okay. We'll leave Ashley Jennings up there with Judge Hepler saying, boy, I just wish you would have never talked. All right. So we are going to send, we don't know who they are, by the way, but we're going to send on over to Ann Taylor's office. We are going to send it's called a Jumping for Joy bouquet. And what do you guys think? Do you guys like that name? We're picking out some flowers. So we have a peace lily plant, a Jumping for Joy bouquet, daisy dreams, an orange sunset. What do you guys like? 20 more products. Let's see what these ones are. Pastel Grace and Wonder. White Sympathy roses, where we need to send to Ashley Jennings. Sorry. Do like Jumping for Joy. You guys like that one? You know what? They have hearts in, I don't know if is it Lanai? Like it's Lanai. And I'm like, oh my God, it's like my name. We should get that one and send that hearts in Lana, basically, with an I. I thought that was funny. I'm like, I don't know. I would just always buy roses. I'm like, yeah, that looks good. Get that. So what do you guys think? Jumping for Joy. We'll get the Jumping for Joy and the orange sunset. How about that? Okay. So Jumping for Joy, we're going to get that one. select one. We'll get the as shown one. Okay, add that to cart. I need more. We need more flowers. Any balloons? You guys want to get some balloons? Congratulations. Get well. Just a big smiley face. Can you just get her a smiley face balloon? Just big one. Let's see. Yeah, we'll do a smiley face. Actually, we can make it say thank you. Fuck it. We'll do a thank you balloon. We'll add some color to it. So you don't get to pick those. I should we send any chocolates? Okay. Well, we got to get a greeting card. You have already added the maximum quantity of greeting cards. God, I only picked one. Okay. Where's my smiling face? All right, remove that. Okay, the occasion. Other. Business. Okay. Company. I don't know. What's the name of the company? Is it like Taylor Law? Does anybody have that address? It's from the team. Are you signing it from Truth and Transparency? Hell yeah, we're signing it from Truth and Transparency. Oh, the card message. Here we go. Thank you for fighting for our rights. And of course, your clients. We appreciate. Anybody else want to say something? Oh, I'm not frozen. I'm talking over here. I'm definitely not frozen. P.S. Tell Brian we said hang in there. Can you please buy Brian a cheeseburger? No balloons. All right. So it just says, thank you, entire team, for fighting for our rights and, of course, your client BK's rights. We appreciate your dedication and time. And I personally enjoyed the slaying, and I personally enjoyed watching Ashley Jennings walk. Ashley Jennings hand you the keys to the Franks hearing. And for all of our rights, yep. Anybody else? How do you guys think about that? You guys like that end? I put PS, we personally enjoyed. We personally enjoyed watching Ashley Jennings hand you the keys to the Franks hearing. Okay. Put love Frank. Best. I put best. Truth and Transparency's entire channel. Even the assholes in chat. Even the assholes in chat. No. Oh. There you guys go. Okay, here we go. Final. It says, Dear Anne, Elisa, Jay, and the two ladies behind the defense. I believe that those are the investigators, if you want my opinion. Thank you. Also, the paralegals and front of the house staff. All right. Dear Annalisa J. and the two ladies behind the defense during the Franks. We have to just put that in there. That way that they know that we're watching. Also, the paralegals and front of the house staff members. We're not going to call them secretaries. We are sending a token of gratitude, thanking. Oopsies. We are sending a token of gratitude for fighting for our rights and, of course, your clients, Bryan Kohberger's rights. We appreciate your dedication and time. P.S. We personally enjoyed watching Ashley Jennings hand you the keys to the Franks hearing. Best. Truth and Transparency's entire channel. Okay? Okay. How's that? Special instructions. Pop out of a cake naked. Thank you. All right. Idaho. I think it's in. Does anybody have the address? All right. Thank you guys so much. we will send this off. I will put the receipt in the community tab, so it's there. And then if anybody wants to add comments to it, they can. And I'll share the link. I'll share the link to the staff. You guys rock. All right, thank you guys so much. We'll be breaking down the hearing from today, the hearing from yesterday, over the course of videos. So Hippler has yet to make a decision, and we will see what happens. So thank you guys. You guys rock. Till next time. Peace out. This November 29th, 4 people that were murdered, and you want to fuck around. You got 8 families that are being affected by this, and